Good morning. Good morning, Chief Justice, Justices of Appeal, Chief Magistrate, Resident Magistrates, Presidents of the Bar Council, Attorneys of the Public and Private Bar of the Turks and Caicos, police officers, invited guests, and very importantly, our learned presenters, Mr. Jeremy Taylor, Queen's Counsel, and Ms. Meridian Kohler. My name is Aisha Difu, and I am Executive Director of the Office of the Chief Justice and Secretary to our Judicial Education Institute, the host of today's event. A very warm welcome to everyone to our JEI session entitled Judicial Consideration of DNA Evidence, made possible by the generous donation of the time of our presenters who are both joining us from Jamaica. A short biography on each of our presenters is contained in the circulated program. And to give you a short overview, Mr. Jeremy Taylor, Queen's Counsel, currently serves as the Deputy Director of Public Prosecutions in Jamaica. He has worked in the office of the DPP for just about 18 years, since 2004. Ms. Meridian Kohler is also a former acting Senior Deputy Director of Public Prosecutions in Jamaica and worked with the office of the DPP from 2003 to 2014. Currently, Ms. Kohler serves on the faculty of the Norman Manley Law School in Jamaica, where she is the course director of criminal practice and procedure and tutor in evidence. Our JEI is delighted to have these very experienced and highly regarded counsel make time to share their knowledge with us. And we are also delighted to have a cross-section of our criminal justice stakeholders participating today. We have judges and magistrates, we have members of the bar, we have prosecutors and police officers with us today. And we look forward to a very vibrant and engaging session. I would also invite all of our attendees to rename themselves so that your name is displayed in the Zoom participant list to help our presenters engage with you. So I now hand over to you, Mr. Taylor.
Good morning. Thank you for that introduction, Ms. DeFore. Madam Chief Justice, judges of the Court of Appeal and the Supreme Court, learned Chief Magistrate and fellow and resident magistrates, President of the Bar Council, members of the bar, both public and private, and I hope you don't mind if I give a shout out to those members of the Office of the DPP in Turks and Caicos who will be joining us, and also members of the Royal Turks and Caicos Police Force. Both Ms. Kohler and I wish to thank you for the invitation to present to you this morning on judicial considerations in relation to DNA evidence. But I wonder, just before we get into the topic, if I may just, because I do see some familiar names, if I may just greet them personally. I don't see many of them here, but I will greet them personally. I think Her Honor Miss Kemble, who is a former colleague at my office, and I mean no disrespect, but good morning, Kerry.
Morning, JP.
I also see Miss Sophia Thomas, who is also a former colleague at the office of the DPP. And I see Miss Kellyanne Francis, who is also a former colleague at the office of the DPP here in Jamaica. And I think I saw well, I don't know if it's the same person, Oliver, if that is the same Oliver Smith. If I may give belated congratulations to you, sir, being elevated to Queen's Counsel. I remember you as one of my interrogators at a commission of inquiry some years back in Jamaica. So,
good morning, Mr. Taylor.
Morning, Ms. Thomas. So, we were asked to look at judicial considerations on DNA, and you see it is called guarding the gate. And when we took this topic, at first, we thought it's going to be DNA in general. And then when we started to look at DNA in general, we said, well, my God, this is such a wide topic. And so we tried in our own way, both Ms. Kohler and I, to narrow it down. So if I may just, Lord have mercy, sorry. My tech skills are abysmal. So when we start out with DNA, in our introduction, we want to look at, well, what is the role that DNA plays? I mean, in 1984, the whole process of DNA identification was pioneered by, I think, a Dr. Jeffries of the University of Leicester in the United Kingdom. And ever since, DNA from 1984 to now has become established. It's hard to believe that it was really only about 30 odd years ago that this science was really seen as new science in terms of its applications in law enforcement and criminal law. So much, and DNA has achieved a status so much so, it's kind of a talisman. It's kind of a way how you measure cogency of evidence. And because of what people understand about the science, especially in relation to the popular domain, shows such as CSI and so on, I mean, prosecutors struggle with cases if they don't have DNA because the jury may feel that the case is deficient evidentially. I think defense counsel struggle where there is DNA because they feel juries may not wish to question the efficacy of the DNA. But notwithstanding the exalted status that DNA has within criminal law and law enforcement, there are certain flaws, especially in relation to how it is collected, how it is preserved, how it is explained, and perhaps law enforcement, prosecutors, and police may place an undue reliance on DNA to the exclusion of any other type of evidence which may support it or corroborate it. And sometimes it can lead to a miscarriage of justice. For example, the Innocence Project in the United States has exonerated many persons, not only with showing how DNA excluded them from being the person at the crime scene, but also exposing shoddy DNA testing techniques. So it is within that context we wish to approach the whole idea of what then are the judicial considerations in relation to DNA. How should judges approach them? How should defense counsel approach them? How should prosecutors approach them? And so we want to start off with the evidence ordinance. And I should tell you that both Ms. Kohler and I, when we were preparing this topic, noting that the invitation came from the Turks and Caicos, Supreme Court of the Turks and Caicos Islands, we have tried to make this presentation very relevant to the topic. So we have tried to use your statutes, we have tried to use your case law where it is applicable in explaining some of the concepts. And we are grateful that you have quite a nice searchable website, what I will call TC-LEI, the Turks and Caicos Islands Legal Information Institute, which we were able to search and look for cases. But here we are starting off with the evidence ordinance. sections 28 and 29. Section 28 basically defines who is an expert, and section 29 speaks about the relevance, 29 speaks about the relevance of the evidence of the expert. So we started off with looking at expert evidence, and because when we go through the presentation, you will see a great emphasis is placed on the expert and how the judge should approach the expert, and by extension, how the prosecutor and defense should approach the expert and his evidence. And the thing about experts is that experts are allowed to give their own opinion. As we mentioned just in the slide before, in relation to the evidence ordinance, the statute allows it, but even if the statute wasn't there, the common law allows it. Experts are allowed to give their opinion. So once the expert has been qualified by dint of years of experience or years of learning or a combination of both, and the court accepts the person as an expert, that person can give their opinions. And you can confront the expert also with contrary opinions, either in published documents and so on. And we rely on the case here from out of the Republic of Ireland, the DPP and Michael Boyce, the decision of the Irish Court of Criminal Appeal. And that was, the citation is 2005 IE CCA at 143. So how will this presentation be approached? So we will start out with part one, a basic breakdown of what DNA is and its uses, and I will present on that. Part two, we will be looking at your statute law and some of the cases from the Turks and Caicos, married with cases from other jurisdictions in relation to DNA, and I will be the one looking at that. And then we'll start to look at the judicial considerations in three parts. Pre-trial, I will look at that. And then during trial and post-conviction, Ms. Kohler will be looking at that. You will see a part 4 there on constitutional considerations. We won't be presenting on it, but this PowerPoint presentation will have it inside there, but we won't be presenting on the constitutional considerations. But you may hear a reference to constitutional considerations arise during the presentations, at least for some of the issues that were taken, such as privacy, liberty of the subject, and so on. So let us start with DNA and its uses. So if you're in court and your expert was there, you would have to start with, what is DNA? What do these initials stand for? And by now, this audience, well and truly familiar that DNA is an abbreviation for deoxyribonucleic acid. And you will be able to find these definitions helpfully set out in the varying bench books. So the Crown Court Compendium of the United Kingdom has a definition, I think a simple enough one, that judges and lawyers who may not be scientists or may not have that scientific background can look at it, read it, and understand it, and perhaps be able to explain it in a way to lay tribunals such as juries. So the Crown Court Compendium has it. And I think that Crown Court Compendium has been the model for other bench books in the region. So if you look at the Trinidad and Tobago bench book published in 2015, you will see a similar definition to DNA there. And if you look at the Jamaica Supreme Court bench book, which I think came into effect either near the end of 2017 or early 2018, you will see a similar definition. And while this is a presentation, especially since both myself and Ms. Kohler are coming from the criminal side of the bar and of the law, DNA arises in other facets that judges have to deal with. So it arises in family law. usually in declarations of paternity and maintenance, especially if the alleged father is contesting his paternity of the child and he does not want to maintain it. So family law, you use DNA there to establish parental rights. You use constitutional law, to arise in constitutional law, rights to privacy. And I think I will segue here that we are expecting a constitutional challenge here in Jamaica to our DNA Evidence Act. An accused person has filed a constitutional motion. It's going to go before the Constitutional Court. I think they're trying to set a date for it to be heard, in which he was arrested for a sexual offense. He was brought to court. The judge remanded him in custody for a non-intimate sample to be taken. And he is alleging that varying rights under the Constitution were breached by doing that. And he's alleging, for example, his right to liberty and security of the person by his being remanded was breached, and his right to privacy was also breached, and his right to be free from unreasonable search was also breached. I think the only right he did not claim was the right not to incriminate himself, but it's going to be a challenge to the constitutional validity of our DNA Evidence Act here in Jamaica. And he is also alleged that there is no other alternate remedy. It can only be a constitutional remedy that he can get. So there is that. As I said before, criminal law, where you use for identification of suspects and also exoneration of the innocent, and also in immigration matters, where you seek to prove the identity of persons coming into your country. I'm going to come back to the bench books, because as I say, the bench books are very useful. And the good thing about these bench books is that they're all online, which I'm sure you all know already. The Crown Court Compendium is online. The Jamaican one is online on the Jamaican Supreme Court website. And the Trinidadian one is online on the Judiciary of Trinidad and Tobago website. So judges, counsel, and I would even say police should download these books and read them. Not only read them, especially police officers, to see how judges are expected to deal with DNA evidence. And this, I think you will find it very helpful when you are investigating your cases and putting them together. We have tried to summarize what the bench books say about DNA when you go through them. So they all start off with the concept of DNA. And when you read these bench books and how they deal with DNA, you will find that a lot of how it is set out has been influenced by the English Court of Appeal case of Doheny and Adams. In the same way Doheny and Adams has adopted a particular structure, I think the bench books follow that structure. So you have the concept of DNA. So the judges started by explaining what the concept of DNA is, what is it, how it is used, and then profiling, explaining what is mixed and partial profiles. The bench books also go on to the interpretation of results, which look at role of the expert, match probability, prosecutor's fallacy. Also, the need for independent evidence, DNA testing and guidance on procedure. And then after they go through all of that, then the bench books go into sample directions, which the judges can look at and adapt in relation to the facts and allegations that are before them in court. So I'm sure you know, you won't just write out the sample direction out of the bench book and just read it verbatim to the juries. It always has to be adapted to the case that is before you. And when we're looking at DNA, and as we started out by looking at how it is seen and what are the flaws, this basically is a summation of all of that we have said. So we wish to point out DNA, where you have it in a sufficiently large quantity, is very useful. And you really can't, it's really difficult to challenge the method. That is my understanding, when you have a sufficiently large quantity. as a scientific tool, you can see it circumvents the whole thing of bias, human perception, and motivation. So it was one of the reasons why DNA evidence was so instantly received into the courts of law, because that aspect of the human condition and the human bias was felt to be, DNA was felt to be devoid of that, even though it is still subject to interpretation. So it also deals with where you have voids in the profile. So if you have partial profiles in which parts are missing, that can be problematic, because an accused person might have an expectation of being acquitted if you don't have a full profile. And you see how the courts address that whole aspect of partial profiles. You also have about the matches. How many loci or places do you use to get a match? I remember in my early days dealing with DNA evidence when I think I was a clerk of court. I had not even reached DPP's office yet. And our forensic lab had actually started out with 8 places or 8 loci. And I think in this recent case that I'm doing, this gang case, they have gone to about 14 or 15 loci now in terms of getting the match. So you can see as the science progresses, more and more loci are being added to say more and more that really can't challenge that this DNA supposedly or allegedly is pointing in the direction of this person by not excluding them. Other considerations about DNA is that DNA doesn't tell you how it came to be there. Well, so DNA doesn't really tell you how it came to be there, or the circumstances under which it came to be there. So DNA just can't march itself into a court of law. So you must have something to explain how it came there, either by a witness or some aspect of circumstantial evidence or forensic evidence. And always live to when you're looking at DNA is the whole thing of tampering or contamination. For example, if I may give an illustration about how that can arise. When DNA testing was in its infancy in the United Kingdom, there was the serial murderer and rapist named Colin Pitchfork. I think he was the first person to be convicted with the use of DNA evidence. And the facts of that case are interesting because he tried to circumvent the DNA testing procedure by getting someone to pose as him and contribute their DNA in the hope that he would be excluded. However, it was discovered before he could carry out the plan. And there's also when DNA breaks down, when it ages, as we say, parts of its profiles will just simply vanish. And so you'd only get you only get partial profiles, or sometimes you will get incorrect matches being made. So all of these considerations have to be kept in mind when you are dealing with DNA. So far from as I say, the popular view out there that DNA is a perfect way of tying somebody to commission of a crime. When you look at it, DNA does have its imperfections. And especially when interpreting mixed samples, well, forensic science warns you that, you have to be careful of the interpretations that you draw from mixed samples, how many individuals, whether there's cross-contamination, and so on. So that is an aspect, as a consideration that everybody should be looking out for, especially prosecutors and the defense counsel. And then and this will come to when we go to looking at pre-trial, have DNA evidence, you, especially prosecutors, you have to evaluate, is it something that I really need to use? So, and we use the example here, both Ms. Cole and I use the example here. What if you have a rape where the defense is consent? Do you really need to bring in a DNA expert to go through all the aspects of DNA when the accused is already saying, yeah, it's my DNA. She and I had consensual sexual relations. Versus, say, another rape case where you also have DNA, but the person is running a defense of identification or straight denial, where in that case, perhaps it would be, it would be very useful. And a lot of these issues, we think, can be settled at the pre-trial stage. And we wish to highlight a case from your jurisdiction, the Queen and Jeff Kenson, in relation to DNA and what is agreed between the parties. We're going to come to look at that case later in the pre-trial aspect of the presentation. But Jeff Kenson is a case about pre-trial agreements and then at trial reconciling from those agreements. So we have a summary here about the concerns here about the DNA. Chief among them, the reliability of the interpretation, the evidence by the statistics, how reliable is the crime stain, what kind of profile is it, full, partial, mixed, how was the profile, is the profile suffer from degradation, and also where the participation of the accused is not an issue. As we just used a while ago, the issue of consent in sexual offense cases. So looking at that introductory part, looking at DNA and its uses, and the considerations which everybody in the criminal justice system have to be alive to, we now go to look at what do the laws of the Turks and Caicos say about DNA evidence. So I think the law that we primarily looked on was their police force ordinance, which has provisions, I think sections 38 to 41, which governs the taking of many different kinds of forensic material, which also include DNA material, intimate and non-intimate samples. It also governs the whole thing of the destruction of those samples. So let us get into it. So the police force ordinance provisions, sections 38 to 41, are similar in phrasing to the Police and Criminal Evidence Act of the United Kingdom, I think section 62 and 63. So when these provisions were being drafted, the legislative draftsman in Turks and Caicos looked at the PACE legislation in England and adopted those provisions. Now, as you are perhaps all well aware, section 39 of the Police Force Ordinance, the PFO, was not the original section that was enacted. There was actually before that a section 37B, which when it was originally enacted, being copied from PACE, they modified the PACE provisions. So the section 37B had a conjunctive approach to sample taking, requiring both appropriate consent and a court order, which the United Kingdom provision in PACE did not require that. And if you look at the table here, we have put a side-by-side profile. So the left column is PACE, and the right column is the original Section 37B of the Police Force Ordinance. And you can see that it is joined by an intimate sample may be taken from a person in police detention only if there's a court order for it to be taken and the appropriate consent is given. Whereas in comparison to PACE, it speaks about a police officer of the rank of inspector and the appropriate consent. It did not have the court's involvement in it at all. Then Section 37B was judicially considered in a Supreme Court case, the Queen and Kingsley Arthur and others. And in that case, you can see an intimate sample was taken from an accused who was in custody, and there was no court order. There was no court order in that. And when you read the facts of the case and you see how the police inspector thought, well, if I have the appropriate consent, why do I really need the court order? I think that was his mindset, although the act was set out strictly, consent and court order. And the prosecutor at the time tried to argue before the court that really and truly there has been no prejudice, but even so tried to apply sang to the facts of the case. This trial, which was being heard by the then Chief Justice, it didn't fly with it. And so he refused to allow the evidence, the DNA evidence in, and he rejected the Crown's arguments that it could rely on sang and similar authorities to assess the fairness of the trial, despite the breach. And I think after both myself and Ms. Kohler have formed the inference that after the decision in Kingsley Arthur and others, the section was amended to bring it in line with PACE. So the significant amendment now with the new Section 39, which has replaced Section 37, is that it replaces and with or. So it is no longer conjunctive, but disjunctive. So it's now person in custody, appropriate consent, or if there is a court order for it to be taken. And then when we are looking at the statute and the procedures, we have to look at what is appropriate consent. And your police force ordinance in Section 38 defines appropriate consent, and it is similar. If you compare it to Section 45ZB subsection 2 of PACE, it is similar. I think the only thing that is different between the PFO provisions and the PACE provisions are the statutory ages. I think in PACE it is 18, 16 and below. In PFO it is 16, 14 and below 14. So these are the persons who can give appropriate consent. A 16-year-old person who is 14 gets the consent of parent or guardian. A person is below the age of 14, consent of parent and guardian. One observation that we made is that there seems to be no provision for persons who may have a mental disorder, mental disability, or physical disability here. It may be something that the draftsman may wish to look at in the event those persons are alleged to commit crimes and the law enforcement authorities seek to collect DNA from them. Perhaps it's something that can be looked at. And so now we come to the whole thing of taking intimate samples. And I want you to know that the acronym here has been trademarked by Ms. Kohler. She has been the one who has come up with it, you know, so that you can remember it easily, soft pubs, because an intimate sample is either semen, swab taken from orifices, fluid, tissue, pubic hair, urine, blood, saliva. So that is how you get soft pubs. And you can see why, based on these kinds of body fluids, other than urine and saliva, why these would be regarded as intimate samples. And again, Ms. Kohler, in her characteristic style, trademarked and copyrighted, as also in relation to non-intimate samples, given you the acronym HONBIF. The second B I've interpreted as being silent. And again, non-pubic hair, sample taken from under a nail, sample taken from a nail, body swab other than from a body orifice, body impression that includes the hand, that excludes the hand, and a footprint. So section 38 sets out these important definitions: appropriate consent, intimate sample, non-intimate sample. And again, we've tried to look at it comparatively, non-intimate samples versus intimate samples. And we start out by looking at this table. One, what is the condition precedent? So we've tried to use certain factors, condition precedent. How do you take an intimate sample versus how do you take a non-intimate sample? So non-intimate samples can come by written appropriate consent, or if you're in police detention or in custody by the court, a court order. Again, it is similar with a slight difference in non-intimate samples. Non-intimate samples can be taken either with written appropriate consent, or if you are in police detention or you're in custody by order of a court, then it may be taken without appropriate consent. So there's this slight difference in relation to the taking of non-intimate samples versus that of intimate samples. So you can see that it can be taken without an appropriate consent. And then if you continue to look at the two sections, sections 39 and 40, you will see that there are also two duties to inform, which are mandatory. It is mandatory that the suspect is informed by the officer. So there's the first duty to inform is where the officer must explain where the sample is being taken by virtue of court order, must explain, one, that there is a court order stating that the sample must be taken, and two, what are the grounds contained in the court order as to why the sample must be taken. And if you look at both sections 39 and 40, they are similar. So both the non-intimate sample and the non-intimate sample are similar in relation to a mandatory duty to inform. Where the court order has been made, shall inform the person from whom the sample is taken. Well, I think I just said that. Duty to inform, two. Again, the officer, so in addition, must also state what is the offense it is alleged that the suspect has committed. Again, this is a mandatory provision. If you look at the language, it says shall. It's a mandatory provision. And again, if you look at intimate versus non-intimate samples, it is the same duty. You must inform the suspect of the offense it is alleged that he has committed. And then we continue to look at the comparisons between the two provisions, sections 39 and 40. Again, both of them have a duty to record. So whether it's an intimate sample or a non-intimate sample, once a court order is made for giving taking the samples, intimate or non-intimate, it must be recorded by the officer, the court order, and the grounds for making that court order. So that's the first duty, to record. And the second duty to record, and I think the inference that can be drawn from here in the first duty, it seems that the person is not in custody. And the second duty is where the person is detained at a police station. Well, the court order, the grounds and so on must be recorded in the custody record. So the first duty is not the custody record, but once the person has been detained or is in custody by order of the court, it must be entered in the custody record. Again, this is a mandatory provision. The other, well, we come now to a dissimilarity. Who may take the sample? And it is interesting because an intimate sample, other than that of urine or saliva, may only be taken by a medical practitioner. But we note that sections 38 to 41 are silent as to who collects the non-intimate samples. I'm assuming in practice that this is really done by perhaps scenes of crime officers who have been specially trained in this area, or they may actually use a medical practitioner to collect the non-intimate sample. But we just couldn't understand as to why the statute didn't go to say who could be considered an authorized person to take a non-intimate sample. And then the other area of difference is in relation to adverse inferences that the court can draw. And it seems that the statute establishes a difference between an intimate sample and a non-intimate sample. So section 39, and if you don't mind, I will just read what is there in the table. Where the appropriate consent to the taking of an intimate sample from a person was refused without good cause, and I know the statute perhaps would not wish to prescribe what without good cause is, and we're trying to figure out what exactly would be a good cause that would allow a person's refusal to stand. The court may draw such inferences as appears proper on the refusal in determining a case to answer, and I think that goes even as far as committal proceedings, or in determining guilt or innocence, and also in determining corroboration of the evidence. So you have that provision there, which has been borrowed from PACE, but for some reason, it has only been limited to intimate samples. There is no provision for it in non-intimate samples. So if a person refuses in really giving a non-intimate sample without good cause, it will be hard for a court then to begin to exercise these powers, since the statute is silent on it. So I think this is perhaps something that the legislative authorities should look at to see if both provisions should not be in harmony with each other. And then you also come back to similarities. What is the basis of the court order? And it's reasonable grounds suspecting the person was involved in the commission of a serious arrestable offense, believing it will confirm or disprove involvement. And I suspect the serious arrestable offenses are the usual kinds of offenses for which I think in Turks and Caicos, you may wish DNA evidence to be collected, that is sexual offenses, murders, or you may even do it for possession of firearms to find out if the particular firearm was in the physical custody of the accused person. So I think those may be the serious arrestable type offenses. There may be more, but those are the three that basically come to mind. And again, you will see that they are both similar in relation to intimate and non-intimate samples. And then the court may order the use of reasonable force for both intimate and non-intimate samples. And again, we'll make a comment here. If there perhaps, and I know the statute is silent on it, the police force ordinance is silent on it, but I wonder if there wouldn't be both Ms. Cole and I wonder if there wouldn't be a place within the statute. And also I think for the protection of police officers, especially if reasonable force causes injury, to be able, before that is done, to issue some kind of warning. So when the person is in custody and you have approached him for his consent to do so, and the court doesn't tell you go and get the court order, you should also warn the person. So it's not enough to give him the court order and the court order says, well, we may use reasonable force. But the police officer should not also give a warning to the person that reasonable force can be used to collect those samples. And then section 41 covers the destruction of those samples, which may be in police custody or databases. And again, we see the kind of forensic material which section 41 covers: measurements, photographs, fingerprints, and also intimate and non-intimate samples, and the circumstances where those samples must be destroyed. So the person has been cleared of an offense, and that is in line with human rights jurisprudence, such as S. and Marper against the United Kingdom, the decision of the European Court of Human Rights, where it has been decided the person who has not made any admissions will only be cautioned and not prosecuted. So those materials are to be destroyed. Person is not suspecting of having committed an offense, and the proceedings have been discontinued. So these are the four categories where there will be destruction. There is one curious aspect about this destruction of these materials that I think Ms. Cole and I noticed. So section 41 goes on to speak about the destruction of copies of the material, of the varying kinds of materials, but it only limits it to fingerprints only. So it doesn't say that if there are copies of the intimate or non-intimate samples, the statute doesn't say that those copies should also be destroyed. And we also queried, well, when you're dealing with the intimate and non-intimate samples, how is that destruction supervised, since the samples tend to be taken abroad to be tested and evaluated? How is that destruction supervised? You take the lab's word that it is. Does the state, if the person requests, and the statute says that the person can request to witness the destruction, and the person wants to go and witness the destruction and say that he is indigent or on legal aid, will the state pay for him to go up to wherever the lab is to supervise the destruction? Since the lab is not in the jurisdiction of the Turks and Caicos, will these orders have any force or merit if the lab decides that they are going to refuse? So those were just some questions that came to mind in relation to the destruction provisions. So again, just a summary of all that was said. The remit of the law is limited. Person not in custody is not expressly addressed by the statute. Outsourcing of lab work may impact on ability to both inspect the working of the lab as well as enforce provisions relating to destruction of samples. What is reasonable force and whether there should be a provision of the suspect being informed prior to its usage, and the distinction between the use of adverse inference between intimate and non-intimate samples. So that is there. And also, I would add, why does this statute say for intimate samples, only a medical practitioner can collect them, but does not identify who would be the authorized persons to collect a non-intimate sample? And so now, after all of that, we come now to the sweet part, the main consideration for this presentation. So we come now to the judicial considerations. And we have divided the judicial considerations into 3 stages. There's a pre-trial considerations, what I will just summarize as saying case management, leading to the setting of a trial date, addressing all the issues as to agreements of witnesses, agreements of facts, agreements of exhibits, expert evidence, and also disclosure. And then you have considerations during the trial, which also will deal a lot with admissibility of the evidence and quality of the evidence, whether it is adequately marshaled, whether it is prejudicial or probative, and also post-trial. And post-trial, you know, we are speaking about appellate considerations. What is it the courts of appeal are going to look at? So let us get into pre-trial considerations. Again, we come back to Doheny and Adams. And Doheny and Adams actually advised that any issue of expert evidence should be identified and resolved at the pre-trial stage. So because they know that this kind of evidence can usually be contentious, and because they know it can also be long at trial, Doheny and Adams, from way back in 1997, identified all of this should be dealt with at the pre-trial stage. So we note that the Turks and Caicos Islands updated their criminal procedure rules in 2021. So this is the present state of the criminal procedure and case management provisions in the Turks and Caicos Islands. From my own reading, I think from scholars' reading, on paper, what you have is a very, very robust case management structure. And I think the jurisdiction where I am from, I am a bit jealous in that you have, you know, these rules set out which seem to cover every kind of eventuality. And there are other aspects which make me jealous, which you will hear me say when I reach to them. But, you know, kudos to the Turks and Caicos for their criminal procedure rules of 2021. In Jamaica, where I think we had some form of rules which may have been gazetted in the, if Justice Marcel was here, he could help me with it, but I'm not sure he's here. I can remember the year they were gazetted, but they have never been used. They're not being used. And so we are still at a stage where, well, boy, we're just depending on everybody's goodwill, rather than have something which would bind them in relation to the agreements. But we looked at the criminal procedure rules, and especially in relation to DNA, we noted that the criminal procedure rules has provisions related to expert witnesses, and they have them there to ensure that the case, once the case goes to trial, they can be managed. So we note that at Form 7 and I had to identify the page at the form because I know that for some of the forms, the paragraph numbering changes depending on the subject area and the form being dealt with. So at Form 7, page 2, paragraph 3, ask the Crown to indicate if expert witnesses will be called at trial. And if it's a case where the Crown is relying on DNA evidence as per the subject of the presentation, we would say yes, the Crown would say yes, expert witnesses will be called at trial. And then Form 7, same Form 7, page 2 at paragraph 9, ask the Crown and the defense to indicate if there are any points of agreement in relation to expert witnesses. So even with the calling of expert witnesses, the criminal procedure rules don't leave it to say, all right, they are going to call us, and then we don't address the issue any further. Case management rules ask for if there are any points of agreement, and I suspect if there are yes, then you state what those points of agreement are. And if there are no, I think you also have to state what those points of disagreement are, both the Crown and the defense. And then in Form 8, which is titled the Hearing Questionnaire, and I looked at the questionnaire, and again, it seemed quite thorough and comprehensive. And I know that, you know, it would challenge my inner laziness because it seemed quite detailed and long. But that's not a criticism of it. I was just saying how the criminal procedure rules in the hearing questionnaire has tried to anticipate nearly any situation that arises in trial and therefore put it down in the case management proceedings. So if you look at Form 8, page 4 of Form 8, will the Crown be adducing DNA? So I say yes, you fill that in. And then at page 10 of Form 8, will the defense be adducing expert evidence? And so the Form 10 here, the page 10 here, if the DNA evidence is being challenged and the defendant is going to bring his own expert, they have to say, and I'm going to come to say something about the case, the CCJ judgment, which will be persuasive in the Turks and Caicos Islands about the disclosure of defense reports. And then 3, also on page 10, let us say that they have the report. Has the defense report been disclosed? And also on the same page 10, if it has not been disclosed, when will it be disclosed? Now, this is one of the areas which I had said before that I like about your case management rules, because it has defense disclosure. And I wish to also tie that into the case of Frank Errol Gibson against the Attorney General of Barbados, 2010-76 West Indian Report at page 137. I think it's referenced further down in the presentation. Ms. Kohler will deal with it, but I just want to say that on the principles established by the CCJ, which are persuasive, but I commend them to the jurisdiction of the Turks and Caicos Islands, is that defense reports should be disclosed if they are going to be relied on, and certainly disclosed in a reasonable time before the defense expert is just put up in the witness box and then it is just handed to Crown Counsel. So this is the utility of the rules. The decision says, well, if you have the reports but you are not relying on it, then you don't need to disclose it. But if you have it and you're going to rely on it, you should disclose it. And the CCJ goes on further to say, boy, the days of when defense counsel can just ambush, for want of a better word, Crown Counsel in these ways, those days have come to an end. Trial is not to be seen as a game or a way to be able to take advantage. You know, these things must be all set out from the beginning, so the court from very early can be able to manage the issues that it is dealing with. Again, some further guidance in relation to case management, and I think that there are many of the rules, well, which anticipate this, even if they don't say it expressly. But the case of the Queen and Reed and Garmson 2009 EWCA CRIM 2698. It's a very useful case. And we would, both Ms. Cole and I would say, in addition to a case like Doheny and Adams, this is a case that I think should be in all judges and Crown Counsel and Defense Counsels in your repertoire. You should keep, because it's a very useful case, addresses a lot of issues. And one of the issues the court in Reed and Garmson sought to address was expert report. So it's not enough just to have the expert report. It must be written in a manner that is easily understood, because in the end, it is not the lawyers who are important in that regard. It is the tribunal of law and fact, who must be able to understand the reports. And in fact, so they ask for it to be easily written and understood. Now, myself and Ms. Kohler, we don't practice in your jurisdiction. This perhaps may already be the practice in the Turks and Caicos Islands. But just in case it isn't, or just in case you are looking for an amendment to your criminal procedure rules, you can actually put that aspect in. Or I suspect a court order can require that the rules are written, that the report is written in a way that not only the judge, but the jury, who it may be handed to, are able to understand it. And then again, and the criminal procedure rules, I think already I identified this, but we commend it again. Both defense and Crown are to exchange expert reports, and disagreements identified, brought to the attention of the court. So where there is no point of agreement, the court should know. The court says the experts must then identify with precision what is in dispute. So there may be call for a further expert report when both the Crown's report, when the Crown looks at the defense report and the defense looks at the Crown report, why there is this disagreement. And this will assist the judge in being able to place the issues properly before the jury. Again, another reason why I like your criminal procedure rules, because it has defense disclosures. I disclose my prosecutorial bias here. So your criminal procedure rules contains provisions in relation to disclosure of material by the Crown. Always, in any criminal case, it is the Crown that bears really the burden of disclosure. Defense really bears no burden unless they fall into one of the categories as contemplated by the criminal procedure rules. And then, so it's not only material, but dates by which prosecution and defense must make disclosure. And again, here perhaps is something which jumped out at both Ms. Cole and I when we looked at that, because there is a provision in the criminal procedure rules that say, for example, if the Crown has not submitted the report by a certain date, and certainly if the court has not been given an adequate explanation, usually it will be that we have not yet got the report. Let's say that there is no good explanation as to why the Crown has not submitted it by a good date. There's a provision that the accused and his lawyer may inspect these materials that are in the possession of the Crown and make copies of them. How does that work if the lab is out of the jurisdiction? Again, it is something that I think must be considered. You have the provision, but it is one that is easily enforceable. And then you also have at Rule 79, prosecution disclosure, and Rule 80, defense disclosure. Defense disclosure, I think in Rule 80, arises if they are relying on a special defense other than alibi. And the forms, again, Form 7 and 8, whether there are issues surrounding disclosure. And what are those? So again, the form tries to ensure that a trial will move smoothly. So all of these are to be ironed out in the pre-trial procedure. So if these rules are followed to the letter, or certainly within the spirit of it, I would commend the Turks and Caicos Islands for having a very robust criminal procedure structure. You know, if the rules are carried out, I think all will go well for the way how trials are conducted. As I said earlier, I am jealous of the rules that you have here. The CPR in Form 8, again, the hearing questionnaire, asks what are the core issues in the case, example, consent, identification, so that the issues can be narrowed down, witnesses who are perhaps non-contentious can be agreed, certain facts can be agreed, certain exhibits maybe can be agreed. In addition, it lists a number of applications that can be made, even at case management, which also includes the exclusion of evidence. So the defense may, even from the pretrial stage, may even ask for certain evidence, say it's DNA evidence, to be excluded, provided they can justify the reason for its exclusion. Now, we come to see what happens when pre-trial agreements are not followed. And the case of Jeff Kenson and the Queen, which we had referenced earlier in the presentation, comes to light here. And that can be found, neutral citation 2020 TCACA at 11. Brief facts. So Jeff Kenson was on trial. At the pre-trial stage, counsel had indicated to Crown Counsel that, look here, the issue is consent, but the Crown had DNA evidence. And so at pre-trial, it was already agreed that there would be no need to call for the DNA evidence because the issue is consent. Well, it looks like Crown Counsel, who handled the matter, was not the one who was at trial, because at trial, and if you read the facts of the case, the DNA expert was actually in Turks and Caicos. But Crown Counsel, who had conduct of the case, again, at the trial and on the record, asked defense counsel if he was maintaining what he said at pre-trial, that the issue is consent. Defense counsel said, yes, the issue is consent. The DNA expert was sent away. And the Crown Counsel opened to the jury that the issue for the jury's consideration is consent. However, as the case went along, the judge became concerned and more than once asked defense counsel, what is the issue? And finally, defense counsel said the issue is not consent, but it is identification. So you can imagine the kind of tizzy that Crown Counsel was put in. Judge had two options. He thought about discharging the jury because of this breach of the agreement, and he decided he would continue the trial, but give Crown Counsel a chance to supplement its evidence with identification. But by then it was just too late. By then it was too late. The DNA expert had returned to the jurisdiction from where they came. Anyway, notwithstanding, the jury didn't believe Mr. Kenson and they convicted him. Anyway, to show how Mr. Kenson was, Mr. Kenson appealed to the Court of Appeal, and this ground was interesting. His ground was competence of counsel. And the counsel did not follow his instructions about consent and went with ID. So Court of Appeal had to consider the whole thing of the agreements pre-trial within the rubric of effective assistance of counsel or competence of counsel. And the Court of Appeal held, and this is a nice discussion here, that a fair trial also applies to the prosecution, that the prosecutor must not be, hampered in the presentation of their case. And paragraph 23 says it, and I'm going to read it. It was obvious that the concession led to the abandonment of the DNA evidence, which would have bolstered the prosecution's case and identification. In the result, it would have weakened its case considerably. Whether trial counsel introduced the concession intentionally or not was irrelevant. The disturbing fact is that the concession was made in open court and the DPP had acted on it to the detriment of the prosecution's case. And if you read the closing paragraphs of this judgment, you will see where Mr. Justice Hammersmith speaks to the ethics of counsel making these agreements and then resigning from them. So it's a useful case when you are looking at pretrial considerations and how these pretrial considerations can affect the conduct of the trial, because in the end, Justice Hammersmith also said that the judge should have followed his earlier inclination and discharged the jury once it was clear that defense counsel had resiled from the pretrial agreement. Now, the other aspect of pretrial considerations which a judge must deal with is facilities for the defendant to conduct his defense. And this may arise where you perhaps have the Crown is relying on specialist scientific evidence, or you will also have, or it's combined also with a defendant who is indigent or on legal aid, or who, even though he is not indigent or on legal aid, cannot afford the provisions of an expert on his own. So it is opposite that I bring to you attention of section 6.2 C and E of the Turks and Caicos Islands Constitution order, which speaks about being given adequate time and facilities for the preparation of his or her defense. And while it may seem that this has been limited to examining person, obtain attendance, and character examination of witnesses to testify on our behalf, the way how the CCJ has interpreted this provision is to give it a more broader purposive interpretation. I will commend that interpretation to you in Frank Errol Gibson against the Attorney General of Barbados, persuasive as it is. But the Constitution does already say that for a fair trial to take place, if it is required, then those facilities must be made available for the use of the defendant. And again, from the judgment, the best time for this issue to be raised and resolved at pre-trial case management, and not at the point when the trial is about to begin. And again, you go back to the list of applications in Form 8, pages 7 to 8 of the CPR. And even if you don't see it as one of the applications, the CPR has a category called Other, and you fit it in there. So it can be put in there. So the CPR of the Turks and Caicos Islands already anticipates and appreciates that these facilities may be needed. And Frank Gibson goes on further to speak about where the equality of arms was so serious and the accused so handicapped. And it may even be a case where it is really the DNA evidence that is being relied on by the Crown to tie the accused person to the alleged commission of the crime. In Frank Errol Gibson, it was a forensic odontologist or a forensic dentist, that's my layman's interpretation, that was needed because the Crown's expert had examined the bite marks on the complainant, compared it to the accused, and said that, well, boy, it's a perfect match. The accused wanted to challenge it. The Crown, there was some agreement with the Crown, and there were difficulties, and the Crown was speaking about the expense. The thing is that I don't think Defense Counsel was clear about the expense of their experts that they wanted. And because of the expense, I don't think he was able to get his forensic odontologist that he wants to challenge the Crown's case. And that is how the case arose. And the CCJ, wrote that, well, the facility really should have been placed at the availability of the defendant. And that it cannot be a consideration that just because the state will have to pay money, plenty of money, that is a reason not to follow through with the provision of the facility for the defense. And if you look at section 21.2 of the Turks and Caicos Constitution, that speaks about the court making all kinds of orders or issuing writs in order to enforce the right of a defendant, which he claims is being breached, or the court finds that it will be breached if he does not have those adequate facilities. So the provision is there, which empowers the court. But whether or not a person requires those facilities, he needs, well, there will always be fact specific, and he will have to set out why this is a case, why the court should make an order that the state should provide the facilities. I mean, Frank Errol Gibson goes on to say, well, you know, in the general rule is that a defendant does not need to be on equal parity. That sounds like a redundancy, but I'm saying it for emphasis, equal parity with the crown, you know, and there is no right for the crown to provide an expert for the defense. So if I go back, it is for the defendant to show that the inequality of arms was so serious and is so handicapped, and based on the factual circumstances of the case, he would need this. Then I see the court being able to make such an order. And at this point, I will close out the pre-trial considerations and the introduction and hand over to Ms. Kohler to take over for the rest of the presentation. Ms. Kohler?
Yes, yes, Mr. Taylor. One moment, let me just make my screen. Are you still sharing?
I'm still sharing. I'm just click my stop share.
Yes, because I think I'm going to have to share. Okay. Let me just start sharing before I start speaking. Share screen. Not quite sure. Oh dear. I have to open my system's preference to give Zoom permission to share. I thought that was already done. You will pardon me all for having to do that. Oh dear. Okay, let me try it again. This is what happens when you migrate to Teams and then forget how to use Zoom on an everyday basis. Okay. All right, let me just get to where I should start from. Yes, I too would just like to say, I think in the Turks and Caicos, it is now good afternoon. I too would also like to say good afternoon. I think Mr. Taylor, and in the interest of time, had already greeted the audience on both our behalf. Madam Chief Justice and all the other judges, distinguished members present, I too am grateful that to participate in this presentation. Mind you, I should say that I'm actually piggybacking. It is actually Queen's Counsel that Lord Morrison had invited, but based on his workload, I think he invited me to come along for the ride, one which I'm enjoying, I must say. And I too also would like to extend a warm welcome to many of my former colleagues whose names I've seen in the participants list. It is a pleasure to make this presentation also before you. Ms. Defoe, I wanted to ask, because I'm aware that, as I've said, it's afternoon where you are. And so I do not know, and Mr. Taylor, Queen's Counsel, has gone on for a while. Is it wise that we take a pause, or should I just go on since it's virtual and I suspect persons can take on dual responsibilities? What say you? What was the plan, if any?
The plan was for this to be one presentation. Perhaps we can ask the participants what their preference is.
Oh, okay.
Like a little break, or would we like to continue? And perhaps you can indicate your preference in the chat. I see our Deputy Director says continue. Our Chief Magistrate says please keep going. Justice Aziz suggests that we continue.
Okay. So, okay, so it would appear that those who are responding are in favor of getting it over with. Okay, I really do hope you will not regret your choice. And of course, Mr. Fu, if the need does arise at any point to stop me for the purpose of the pause, I may even stop. I just realized I probably need more water. After talking for a while, it comes in handy. The truth is, this being an area that is not new, but the presentation of like the paper in the area is new somewhat, and on a territory whose law we do not know so well. I think we took everything along with the kitchen sink from a presentation standpoint. And so there's quite a lot that is still left. But where are we at this point? No? Mr. Taylor took you through the introduction to DNA evidence and its uses, as well as the law in your territory and other law that would also arise. And he took you through the pre-trial aspects of DNA evidence. And of course, we're doing it from, as we've said, the judicial consideration. So of course, while all the other players do come into the mix, we try to take that slant as much as possible. Yes, and so as you've seen it, we've named it here the tripartite considerations, because we have divided it really into pretty much following a criminal matter: the pre-trial stage, the trial stage, and the post-trial or the conviction stage. And I'm now going to pick up from here. That is during the, oh dear, during the trial. Let me make this small. All right, good. Now, I'll give you a warning if you see me relying heavily on my slides. Okay, so where am I? Okay, so this is the most difficult aspect for any judge in a trial where DNA evidence has to be considered, the trial stage. And I've broken down this area into three categories: the admissibility of the DNA evidence that has to be considered, the directions that is given by the learned trial judge in the summation, and of course, as this aspect that obtains during the trial itself, how the evidence is marshaled and explained. That is whether the DNA evidence was properly marshaled by the advocates and explained by properly qualified experts. Now, as I've said, even though this is the responsibility of the judge, the learned trial judge, it is one that she shares with the expert himself or herself, the defense and the prosecution. And I've relied here on the Australian Law Commission report of 2003, essentially yours. It's a bit long, but it is definitely worth the reading. So we begin. In order to evaluate DNA evidence properly, the jury, the finders of facts, must have sufficient understanding of DNA analysis and the statistical calculations used to determine its probative value. And I pause here because it is quite clear that if the jury is going to get a sufficient understanding, it also means that the expert must have that sufficient understanding. And the counsel who are leading the evidence or cross-examining the expert must also have that understanding. And the trial judge herself must also have it. So we see in the case of the expert, it is his role to explain the science and the technology of the DNA analysis, the interpretation of the results and their significance to the jury. The defense and the prosecution must also have sufficient understanding to examine or cross-examine the expert witness appropriately. And the trial judge, who must then do everybody's work at the end of the day, must have sufficient understanding to properly direct the jury in the evaluation of the evidence. So I'm now going to look at each of these parties separately. And I'm starting with the role of the expert. You will note that I'll perhaps skip some slides at points in the interest of time, no? Because, yeah. Okay, so I started with a quotation from the case of the Crown and Cargo. And it notes that the expert is expected to be appropriately qualified. The expert must undertake his work conscientiously and appropriately and acts impartially. Because we know, of course, that though the expert may be called by the Crown or the defense, in a sense, he becomes an officer of the court. And therefore, the evidence is important that bias is kept out of the picture. Yes, and so it begins by saying a witness who gives evidence as an expert must first of all establish his or her expertise in relation to the matter upon which she is to give evidence, right? Because I mean, in the first place, that's why the expert has been called and allowed to give opinion evidence, because he or she has a known and verified, and should be verified in the court, expertise in the matter. Any primary fact relied upon by the expert must be proved by admissible evidence. So that's one thing. Yes, if it's in relation to a primary fact, it must be proved by evidence that is admissible. But there's another category. There are other secondary matters, such as established scientific norms, practices, standards, and reference points within the field of expertise, such as a census, distribution of blood groups among the population, scientific norms, such as the coefficient of expansion of particular metals, which he or she may rely upon, or any such like material. And of course, the expert must be entitled to refresh his or her memory by reference to textbooks or other scientifically accepted sources, or to refer to them to confirm and explain his opinion. Yes. And of course, these secondary sources you recognize do not have to be proven in the same way as the evidence that the expert or the opinion the expert is relying on to support the primary facts in the case. Now, Mr. Taylor, Queen's Counsel, already referred to this case, Reed and Gamson, and I certainly second it, that it's a very useful case in appreciating the concept of DNA evidence, especially when there are many issues surrounding its admissibility, as well as the facts themselves. All right, in this case, the court listed 3 bases on which to consider the evidence of the expert. The first one is that expert evidence of a scientific nature is not admissible where the scientific basis on which it is advanced is insufficiently reliable for it to be put before the jury. And of course, I don't think that issue would arise when it comes to DNA, perhaps 30 years ago, but where we are now, the science, even though it continues to develop, yes, has reached a stage where it has been well proven by the court, so much so that the courts no longer accept the questioning of the validity of the existence of this evidence, or even if it is reliable at large, reliable in the context of the case in which it is being called, but not in general, no? But even while we know that, you note in bracket I have here that there is, however, no enhanced test of admissibility for such evidence. Yes, so the court is saying that we're not going to now create a new test or a new threshold, yes, that is going to be used for the advancement of scientific evidence. It is just that, like every other evidence, satisfying relevance and satisfying reliability, DNA evidence, scientific evidence is no exception to that rule. Second, even if the scientific basis is sufficiently reliable, the evidence is not admissible unless it is within the scope of evidence an expert can properly give. Yeah, so you see the court here putting a boundary on the expert. The expert is not at large to just come and say whatever it is. that he or she wants to say. And for those of you from the DPP's office, I'm not quite sure if there are any defense counsel in here. We know very often that once the expert gets into the box, especially if called by the defense, that the range of questions seem to know no bounds. And I'm sure prosecutors, admittedly, also commit that sin. So I'm not trying to put it all in the shoes of the defense. It is just that the court says that it has to be within the scope of evidence that an expert can give. And it is not only evidence in the scope that an expert can give, but the particular expert who is in the box must be able to give that evidence. I think it was in Reed and Gams that the court was very sharp with a number of the experts who came and rejected them in very strong language. To be honest, when I read it, I kind of felt bad for the poor souls, because I'm like, this thing is for posterity. Anybody can go and read it. And especially as an expert, since whichever case you've given evidence in properly, you should report that as part of your representation overall for another court. These experts are going to have a hard time after that. Yes, there was actually one particular expert in the Reed and Garms who had given evidence that appears in a way that the court also thought it wasn't strong, and that was brought up in that particular case. So you see, the expert is not just thinking solely of the duty to the court, or should not only be thinking of that, but for his own professionalism, he should ensure that these rules are followed. And of course, he or she, where are we now? We're at the third one. Unless the admissibility is challenged, the judge will admit the evidence. And I think when I read that first, I paused, and then I realized, well, indeed, if you have two sides in an adversarial matter and there is no challenge, and clearly the first rule of evidence must have been satisfied, that of relevance, and what basis would a judge not admit the evidence in these circumstances? And it says here, it goes on to give the logic for this reasoning, that it is the only pragmatic way in which it is possible to conduct trials. However, if the objection to admissibility is made, then it is for the party proffering the evidence to prove its admissibility. So clearly, whether it is the Crown or the defense, if they put the expert in the box and there is a challenge to the admissibility, then you find clearly that that party is going to have the responsibility. And in my former life as a prosecutor, I do recall cases in which the Crown may have moved on without properly establishing the academic qualification or the practical experience of the expert, and the defense would jump up and loudly object. And judge would, of course, go, yes, upheld. Yes, Madam Crown, what else do you need to do? And so, yes, one appreciates the need for that, especially given the nature of this sort of evidence, that there shouldn't be any sort of secret per se around what it is and what its usage is for. Now, these two slides here on the expert, I think I'm just going to skip by, because it's really getting to an extent into the details of Reed and Gams, and the facts of which I've not given you because of time, and which you can, of course, read on your own. But I thought it was still interesting to actually itemize them, and have done so here. The second slide, same thing, really addressing whether or not the expert can express an evaluative opinion, even in the absence of a database or in relying on a particular hierarchy, and the court addressed those particular points. It's 2 or 3 of them. No, I think I want to go back to the last. Oh dear. No, I want you to go in the other direction. Yes, I did want to skip those. This is the last question, the last slide on the expert I wanted to look at, that of the Crown and Michael Boyce. Mr. Taylor made reference to it. If you notice, we're using the Court of Appeal judgment here. This matter was actually appealed to I think it's the Supreme Court, Mr. Taylor, for Ireland, but it does not affect the judgment of the Court of Appeal at all. Yes, because the points on which it dealt were way narrower, but it's a good read nonetheless. But the points on the DNA were really explored at the first rung of the appellate level, which is where we remained. No? So it says here, I've isolated one particular point. It says, in the course of the judgment, the court noted the impropriety of asking the expert witness whether, and it's here in quotes, what do you say about the need for or the importance of something other than DNA to assist your analysis in the presentation of criminal cases? And this is what the judge said. The judge says, as the scientific witnesses at the trial pointed out, and Dr. Smith had laid specific emphasis on, their function is simply to give expert evidence of the objective scientific data discovered by them and any associated expert opinion in relation to it. And it is not for them to say how valuable it is in the context of the issue or the guilt or innocence of an accused. The admissibility of evidence is a matter of law, a matter for the trial judge, and the weight to be attached to it in the context of the evidence as a whole, in principle, is a matter for the jury. So you can see from the response, first of all, the impugned question of asking this was a case in which there was really mostly just DNA evidence. And the defense was running that, the DNA evidence alone can't stand, you barely have anything else. And they're trying to get the expert to agree with them that that is so. So the court said, no, you're not supposed to go there. And of course, the point was taken on appeal. But if you notice here, the expert actually did the right thing. So, and this is why I kept in that part, because it's not only that counsel asked a question that was inappropriate, but the expert properly tapped counsel on the wrist and said, no, I am not able to do that. My function here is limited to. So you see, this is an instance where this is clearly an expert with experience who recognizes that what he goes to court to do and the confines of that, what it imposes on him. Although, of course, counsel would happily overstep it if permitted. All right, so that is the wrap up on the expert in short. And we're now going to look at the role of the prosecutor. Or perhaps I should tie the expert back into the judge, although it's quite clear on its face, no? That the judge here, as the gatekeeper, would ensure that the expert indeed remains within her lane, for want of a better term, and that the parties in examining or cross-examining and even re-examining the expert, they too remain in accordance with what is expected in law, what is allowed, what is permissible in law in terms of what the expert can say or do. Okay, so the role of the prosecutor. This slide here just represents a summation of the points that I have looked at, or if not in any detail, certainly address that they should be considered in this context. So, of course, the prosecutor is a minister of justice. I like to tell my students, you will forgive me if I call it students too, that as a prosecutor, really, you wear two hats. And that's why my head is so big, because I am appearing for the crown, but I'm also a minister of justice. And so all prosecutors need big heads. And if Mr. Taylor and myself are anything to go by, we clearly fulfill that particular criteria. Sorry, Mr. Taylor, picking on your head. Okay, so then you have early and complete disclosure. Then you have knowledge. And Mr. Taylor has addressed that really from the pretrial stage. So I don't think I will go in any detail on it. Knowledge about the DNA evidence. Indeed, as a matter of fact, in some of the readings, they say the prosecutor or counsel on the whole should be experts. Of course, we can't be experts. I mean, we're already out of our water as it is. And there's quite a lot of, you see how much DNA encompasses. But I think the lesson to be taken from it is that in each case, as you go by, you really should make yourself so familiar with the case that indeed you appear to be knowledgeable on all aspects of DNA evidence, because that is the only way in which you can properly assist the court to carry out its role, by carrying out your role properly. And that means doing the fundamentals that is necessary to allow you to do that, which is to competently present I've written it as competently present the expert as well as the expert's evidence. Yes. Okay, so we're up to the next one. Okay, I hope I didn't just tell you everything that I plan to now share with you. Not quite. Okay, so the prosecutor has a responsibility. Yes, prosecutors, we know, are presenting the evidence and to ensure that the evidence is led in a manner that the trier of facts, whether it be the judge or the jury, have sufficient information to understand the evidence adequately, because they have to understand it. They have to be able to evaluate it. And if they're prepared to accept it, they must know what weight they're prepared to attach to it. So when you bear these things in mind, as you prepare for a trial, much less leading the evidence in the box, then it makes it more likely that you will fulfill this role in the manner that you're expected to. So as we've said, the prosecutor must also have sufficient knowledge that she can make a correct determination of how the expert evidence properly fits within the case and how it is to be led. Yes, so we have to know the theory of our case, yes? Because unless you know how it fits into your case, then there's going to be a problem, yes? And oftentimes we find that prosecutors will appear before the court without fully fleshing out or fully being cognizant of what their case is. More so, well, I probably shouldn't say so often, because more so perhaps that's more of a flow of the defensive side. And I'm not throwing any stones here, because preparation is something that we all live by. But we know that sometimes within the ambit of the number of cases that we take before the court, not knowing necessarily which one is going to be tried, that very often that you are faced with a case that you haven't carried out the level of preparation that is required. Although perhaps by virtue of the pretrial case management system, by virtue of your CPR rules that exist in the Turks and Caicos, and also to your caseload, this is not an issue that you face. It's not like the 100 or 200 cases that the prosecutor heads out to circuit with in your sister jurisdiction. Yes. Okay. The prosecutor must properly assist in the explanation of the evidence to the court. So of course, we know DNA, being a science, is going to have its own lexicon. And of course, the expert, especially if you're calling an expert who doesn't often come to court, will have a way of using that particular lexicon, or using acronyms and abbreviations associated with that science. And even when they think they've broken it down, it really is not down low enough. And so the prosecutor oftentimes will have to go, yes, Dr. So-and-so, a while ago you told the court, you see, therefore, and that is further broken down, yes? And they must ensure that the evidence is presented accurately and that its significance is not misrepresented. And when we get to the prosecutor's fallacy, we will consider that whole issue of misrepresentation. So yes, getting back to the skills of advocacy, the prosecutor must lead, chief, and re-examine. And of course, the prosecutor must of course ensure that the expert that is going to be called is appropriately qualified. And these qualifications, like I intimated earlier, has to be led appropriately. So there's sufficient detail that the judge and the jury fully appreciate the background experience of the witness. Yes, so don't just let the witness just rattle off, which sometimes they're used to as per their statement, they rattle off a few lines and that is it. Especially if by virtue of how the evidence fits into your case, it is important to highlight a particular skill, expertise, practice in the area that that expert has. It is worth certainly probing deeper to ensure that that is fully understood. And as it says here, it's not just the formal qualifications of the expert, but the practical experience also, which carries significant weight. I recall sometimes when you call the doctors who do the post-mortem, I'd like to lead, you ask them, they say, yes, they perform post-mortem, and then you ask how many, and when the doctor tells me 2,000, and I have a body that has no head or was not able to be recognized well, and the doctor's evidence is really important, I think, wow, I'm glad I led that evidence that he's done all of 2,000 post-mortems already. Yes, it's not DNA, but you know what I mean in that context. Okay, so it is not simply the formal qualification, but the practical experience, as we've said, that carries significant weight. And therefore, it is important to highlight the features of the evidence that also reflect the independence of approach by the expert. And this may include charter of the organization in which the witness works, whether the organization is accredited and what that involves, whether the work conducted is at the request of both the prosecution and the defense. I don't know if you have instances where work that is done is actually at the instance of both parties, but it is interesting that that level of collaboration is suggested and can be used, yes? And whether they expose their views, that is the expert, to the forensic science community for scrutiny, whether the testing procedures are such as to eliminate impartiality, and whether the information about the organization is accessible. Also, it is important to find out, if possible, details about the expert, including what views he has expressed previously, because you clearly don't want an expert coming to say A when earlier he said B about the same point, unless there is, of course, a reasonable basis for him to do so. And I mentioned this already, the need for ordinary language to be used and for the discipline and the methods necessary so that the court is properly able to evaluate the opinion expressed by the expert. As Queen's Counsel intimated earlier, your as we understand it from the research, you send all of your lab work to the, what is it called? The International DNA Lab. in Florida. I actually did go online and looked at their site and, you know, and their write-up, and they seem pretty impressive, just looking at it from that standpoint. But as Queen's Counsel said, I wondered then how much the defense or even the Crown themselves know in detail about how they operate and the extent of the reports that are provided. And this is not to in any way cast a shadow on what you did, because what it made me do also is to reflect on my time at the DPP and honestly how little I know about what the government forensic lab does. I mean, we had a handful of persons who would always come, and over time you develop an understanding and appreciation of their work and experience and professionalism. But honestly, through this reading, this presentation has forced me to do, I really didn't think, I certainly never dug that deep as you know, in terms of preparing the expert or even being aware myself as counsel, how deep the preparation must go. And I don't know that defense counsel, that we provide them with reports that allow them either to dig that deep. But as Queen's Counsel said also, to perhaps because of the level of pre-trial prep, pre-trial management that you have, perhaps all of that is well covered in disclosure, because when we trawled your site and looked for cases, we really didn't see many points or cases fighting the issue of admissibility. And I thought that was probably admirable of how well the criminal justice system in that extent, or to that extent, functions, or it is, you know, significant to something else. I don't know, but I took it in a positive way. So having covered that now in relation to the prosecutor, we're still looking at the prosecutor. So we're looking at the role and the fact they have two heads like Janus, and we're now at the prosecutor's fallacy. And I give a caveat here. This is the scientific explanation of it has always eluded me in a sense, even though I understand what it is. So if ever I'm going to stick to this slide, like butter to bread, it is going to be when I present the prosecutor's fallacy. But I must also say, I also discovered, or we discovered, Queen's Counsel and I, that there's also a defense counsel's fallacy. And when we get there, we mention it. I wish I'd known about it when I was a prosecutor, no? Because when I read up on it here, I'm like, but they've done it so many times. I wish I could have gotten up and made that argument. As often as they got up and made the argument about the prosecutor's fallacy, but hey, you live, you learn. Queen's Counsel, Mr. Taylor is still in the trenches, and I am sure that he will be employing it. Okay, so I'm going to read the first paragraph only though, so you will be spared a bit. The prosecutor's fallacy is an error in relation to probabilities that usually favors the prosecution. And it can occur or be raised by more than one person. So you see here, the forensic scientist could actually make the error in presenting the DNA, presenting the evidence to the court. The judge or counsel, despite the evidence being properly led, may inadvertently commit the error. Yes, in the Crown summing up their case and the judge summing up to the jury. And the third possibility is that the jury could make the error in applying the evidence, even though the evidence has been presented and summed up correctly. So you can see the nature of the error itself is quite pervasive. And even to those who at the end of the day make the decision, they, despite everybody else doing the correct thing along the line, could still get it wrong. No? And here we have an example of what the fallacy is. And perhaps it's better to go by analogy than just the raw theory. So the prosecutor's fallacy occurs when someone incorrectly believes that the probability of a random scientific match is equal to the probability that the defendant is innocent. And here's the example. Imagine a case where the defendant's blood matched that of the perpetrator of a crime. This blood type is so rare that there's only 1 in 1,000 chance of someone possessing it. If you interpret this statistic to mean that there's only 1 in 1,000 chance that the defendant is innocent, you are a victim of the prosecutor's fallacy. You improperly conflated random match probability, that is the frequency of the blood profile, with source probability, that is the frequency, that is the probability that someone other than the defendant is the source of the blood. And therefore, in a town of 1 million people, there will be roughly 1,000 people with the rare blood profile. Therefore, while it is true that there is only 1 in 1,000 chance that a random person's blood could match the criminal's, the odds that a person who matches the rare blood profile is innocent based solely on the matching evidence, so we're covering everything else, just using the matching evidence, is actually 999 in 1,000. So you can see now, if one goes wrong there, how wrong one would have gone. And I think Queen's Counsel mentioned that we've actually prepared a paper or are in the process of preparing a paper to accompany this PowerPoint presentation. And there you would see us go in greater detail, as well as mention all the sources, not only Mr. Conklin, who I must confess has done a wonderful job of all the different sources that I've read of explaining it. And we're going to meet him again when we get to the defenses using the same example. No? So as we'd say, stick a pin where the example is concerned, because we will revisit it. So that is it you have for the prosecutor and the role or the dual roles that she has in assisting the judge in carrying out her function. Am I saying only hers? Oh no, I made the expert a male for most of the time. Okay, because the sexual bias can work the other way, you know. Don't want to be guilty. So getting to the role of the defense counsel, and I'm going to call it him in this case, just to balance the thing. So what can the defense do? Oh, the side thing is still saying prosecutor. It should say defense. So, role of the defense. In relation to the defense, in DNA evidence, the defense can make challenges to the scientific validity of profiling and matching techniques, the quality of the forensic lab standards, the qualifications of the expert witnesses, and they can also use of statistical calculations of DNA match probabilities using the distributions of genetic variations within the populations. So pretty much questioning the basis of the opinion of the expert, yes? And I go back to our friend, Michael Boyce, and look here at what the points that were expressed there in relation to this. It says, counsel for the defense are in principle entitled to put to an expert witness extracts from expert textbooks or other expert treatises. If the expert witness, being cross-examined, accepts a proposition cited to him in cross-examination from such an extract, then that proposition may be treated as evidence, it having been adopted by the expert witness. However, and of course, many of us have, this is the experience we have, especially from the prosecutorial angle, that the defense comes, they have all of these books, or sometimes no book, perhaps something scribbled on a paper, and the question is then asked of the expert. It says, if the proposition cited from the extract is not accepted by the expert witness, then it is open to counsel for the defense if they consider it appropriate to call expert evidence to support that proposition. And such expert, of course, may rely on or appropriate the proposition cited from the textbook or treatise. It is not the case, however, that because counsel merely cites or puts to a witness what he or she claims to be expert evidence from whomever, this is the wording of the judge, by the way, you know, from a work of whatever date and whatever provenance, that it becomes evidence for consideration by the jury. Yeah, so of course the distinction has to be made between a proposition that is put to the witness and that the witness accepts it, because in counsel's right and in carrying out his responsibilities to his client, it is proper that that is done, but only those propositions that are accepted becomes evidence. If they're not accepted, there's the alternative of getting a witness or unfortunately having to abandon it because it isn't evidence, yes? And I put here in quotation, noting that inexperienced counsel lacking access to qualified defense experts are not well suited to vigorously cross-examine government experts. And this at all is not a slur on defense counsel. It's really looking at the fact that for the most part, a lot of the persons who find themselves before the court in criminal matters are actually quite indigent. And of course, unless legal aid is set up in such a way, unless pretrial case management is set up in such a way to enable, and of course, discovery of the documents, disclosure is done at an early stage so that counsel knows how the DNA fits in his case. And if he requires DNA for his client, then he's unable to do that. And also to, in some instances where very young counsel, whether by legal aid or by private retainer, take on matters that they really are not ready for, that, of course, again, it gives the court extra responsibilities to make inquiries to ensure that there's a balance. And you heard that mentioned in Frank Gibson, especially the area of science, odontology, which was at the time, perhaps it's different now, was not so settled. And really that was all the court had, the Crown had for the most part, the fact that the victim seemed to have bitten the accused or her attacker at the time before he murdered her. And tada, this man had what an odontologist has said. The victim is a bite mark, and tada, it matches the teeth of the poor victim, deceased, yes? And so if it is that counsel perhaps had not had the vociferous lawyer that she had, perhaps that sort of representation would not have been sought. Representation would not have been made to the state. That state, in a case like this, in honoring my constitutional rights, I should be allowed legal aid. The state should pay for the lawyer. Yes, and you saw it coming up again. I think it was what, Eli Gibson from the St. Kitts and Nevis, a similar point, and the court treating with it. Yes. So the point is, early disclosure is important if there's going to be fairness in the criminal justice system and a proper ability to weigh if the any evidence is being relied on, the nature of the evidence is being relied on, and whether or not indeed the defense need to call their own expert and at whose expense. But again, as I've said, by virtue of your CPR, I don't think these are issues that you have. So you will pardon myself and Queen's Counsel. I think he has already apologized for that some of our comments that we make perhaps have absolutely nothing to do with how practice devolves in terms of Caicos, and really more so with where we ourselves have practice or are practitioners. And I won't go through this slide again because I think we've made sufficient reference to it, the Frank Errol Gibson. But it's there for you to go back and have a look at. I step on that one. Ha! We're at the defense fallacy, I promised you, no? And I'm keeping my word. However, I'm going to have a short pause for the purpose of getting myself a glass of water. I've drunk all that I haven't. I don't want to croak out before I'm actually done. So will you give me just a minute and I'll be back.
Yes, of course, Ms. Kohler. Thank you.
Probably took 10 seconds. No? Clearly, for it to take a minute, I would need a bigger house or something. But anyhow, back with the water. Okay, Ms. Defoe, I'm continuing, right? Tall. Okay, so
Yes.
defense fallacy. Yes, Ms. Defoe, you wanted to say something?
No, Ms. Kohler, I was just thanking you.
Okay. It's my fault. You will notice already that I speak somewhat quickly, no? So I ask you questions, don't give you time to answer and just run ahead. You know, as a prosecutor, when I used to appear before the jury, I used to practice ensuring that I would modulate my tone and be a little slower, and it worked perfectly. And then I stopped appearing in court for the most part. So I do hope the speed that I'm going is not in any way affecting the uptake in a negative way. Of course, if it is doing so positively, then hurrah. Okay, the defense fallacy. And again, I'm going to be a slave to the particular slide. It says, and this is our same gentleman, Mr. Conklin, as I promised you, he would have returned. The defense attorney's fallacy is a variation of the prosecutor's fallacy, where the jury is encouraged to disregard associated evidence as irrelevant, regardless of how rare the matching characteristic is. To illustrate, imagine a trial with the same blood match as before when we had the prosecutor's fallacy, but with additional evidence against the defendant, such as an eyewitness and the possession of the instrumentality of the crime. A defense attorney might nevertheless tell the jury that there's only 1 in 1,000 chance of the defendant's guilt. While this would be correct if the prosecutor's case was based solely on the blood match, the defense attorney is asking the jury, in effect, to disregard all evidence except the blood match. So this is a defense attorney's fallacy. And if the defense attorney is successful in getting the jury to believe this defective logic, the additional blood match evidence can work to erroneously reduce the jury's perception of guilt. And I think Conklin also makes the point that in O.J. Simpson's case, a similar argument was floated. So for those of us who are biting at the bit to go and find out, when we read, you go to the Houston Law Review, you can delve in. So there we are. We're now at the role specifically of the learned trial judge, and not just the other roles that complemented hers. Yeah, so remember, we looked at the expert specifically, we looked at the prosecution, we looked at the defense, and now, as I say, we're going to delve here. And of course, this is not an exhaustive list by any means necessary. We just simply, Mr. Queenscones and I just pulled some areas and said, all right, you know what, let's look at these, yes? So the areas considered, and in no particular order, which is why I use a circle there, so nobody can say that I never stick with it. So there's the summation, there's the mixed partial profile, which I think Queenscones touched on already, the sole evidence being DNA / a no case submission being made on that basis, whether the evidence is more prejudicial than probative, of course, just to keep out the prosecution's evidence, whether voir dire should be held, you know, in terms of the admissibility, then there's chain of custody and DNA as circumstantial evidence, more than just clearly saying without more 100% who done it. As Queenscones said, told you, DNA says who commits a crime. It can tell you who they find in a crime scene. How did it get there is another thing in many issues. Okay, so let me see where I want to start. Okay. Trial judges ruling on admissibility issues or subsequently directing juries on aspects of complex scientific evidence, and then summing up on such evidence at the end of a trial, can expect close scrutiny by the appellate courts. So it's such an onerous responsibility in itself, yes? So the judge has to marshal everybody else who's in the court, and having done her best, she's still subject to the close scrutiny of the appellate courts. And the same applies to decisions admitting scientific evidence in a criminal proceeding, particularly if a court of appeal takes the view that the probative value of such evidence is outweighed by unfair prejudice to the accused. So that's just an open quotation to basically get the ball rolling. Now, I found this study from it was done in 1997. With the way time goes now, it sounds like it's a bit old, but I actually think it is still quite relevant. Mind you, when I looked it up, I was trying to find a free copy. They're actually selling it as a book. So to show you that it's still very much in demand. But why I find it so relevant, or we found it so relevant, Queenscones and I, is really because it spoke directly to judges. Yes, so judges, a big questionnaire was done on, I think it was a scientific evidence on the whole, not limited to DNA. And judges were being asked a series of questions and to fill out the survey. If I recall correctly, though, of the 100% of them, which was like 200 odd judges in Australia back then, 297 or something in that region, I think only 52 of them actually completed the questionnaire. I don't know what the Chief Justice would say to that, but yes, I did have a small smile when I realized that, yeah, it was pretty much the half of them that had filled out the questionnaire. And I say that again, so that statistics don't lie. And then, of course, you can see the results flowing therefrom, that it wasn't 100% concurrence, yes, or take up. So the judges were asked inter alia about the most serious problems that they encountered in expert evidence. 34.84% of them said there was bias, meaning they found that the expert tended to be biased towards a party that called him, meaning, of course, ignoring his duty to be conscientious and impartial to the court. 13.93% said that there was a failure to prove the basis of the expert's opinion. And clearly that has implication not just for the expert himself, probably having failed to do it, but also for counsel in terms of the advocacy. In terms of course, the person who called the expert, it would have mean the Crown or the defense failed to ask the necessary questions. Or it could mean, of course, that expert wasn't as properly prepared, and that should have been discovered by both parties from day one, that the base of the opinion is on shaky grounds or no ground at all. Poor examination in chief by the advocates, well, there you go. but that's not big. So that's good. That's good for the advocacy at the bar. 13.93%. So bias really is the biggest percentage. Huh? Then we get to a failure of the advocate to cross-examine so as to make the expert accountable, 10.66. And I ask you, what do you think that is attributed to? Is it a lack of knowledge on the part of counsel? Yes, for whatever reason that lack of knowledge exists, so that there's this inability to cross-examine the expert in a way that is going to undermine or threaten the reliability of the evidence. And of course, as I've said, it goes both ways because we don't know who's which side we're talking about that's calling the witness. The use of oral or written language by the expert, which was difficult to understand. So there we go, going into the lexicon. And I've said the poor expert thinks he's broken it down sufficiently, and we are still not getting it. Yes, exceeding the parameters of his expertise. Indeed, so we realize experts can do that. Remember, we talked before about setting their lanes and then remaining in it. So he comes to talk about A, comes to ask him a question on B, and even though B is not his forte, he delves in this long explanation as to why B is B. Yes, and of course, no surprise, responsiveness by the experts to the questions, but that is less than 5%, no? That the expert is actually non-responsive to the question that has been asked. We're continuing the question here, no? So we're still there. In response to a question about what, from their perspective, were the most persuasive factors in a jury accepting expert evidence, they listed in descending order: clarity of expression, okay, impartiality, prior experience in the field, and familiarity with the facts. So in that descending order, that is how the judges felt those were the most persuasive factors in a jury. I don't know if our judges who are present today share that view or that order for that matter. And here now, I think this is the summing up. And of course, because each summing up is going to be specific to its own case, I did not seek to say what a summing up should have in at all. I actually, well, we here just sought to look at one summing up in which the court was over the moon with the judge and pretty much just touched on some points that they felt the judge was really good at, the trial judge. And so I put it here because it reads well, So it says, we are satisfied. I think it's from Reed and Gamson. But when I get to the next slide, that will be known. We are satisfied that in the summing up, the judge properly directed the jury on all the issues relating to DNA. Indeed, we wish to pay tribute to the way in which the complex issues were put before the jury by the judge. And of course, I deleted some of the things. No? After summarizing the basic science of DNA, the elements of the process of profiling, and the concepts of match probability and partial profiles, he summarized the evidence of the analysts pointing to the specific strengths, the weaknesses, and specifically issues as to the extent of the reliability. The judge also pointed out the essential criticisms leveled at various aspects of the DNA evidence by the defense. And yes, it is from Reed and Gamson, that's correct. And the judge emphasized the limitations of the DNA evidence. And to round it off, they ended up by saying, in our judgment, the summing up was comprehensive and unimpeachable. And I think those words are words of gold for any learned trial judge who's slave to a trial coming from the court that will indeed judge the summation. And of course, I put here sources of summation guidance. Queen's Counsel already mentioned them. Outside of Doheny and Adams and the usefulness of Reed and Gamson, we have the various bench books, and indeed the Crown Court bench book is what, and admittedly so, the Jamaican bench book and the Trinidad and Tobago bench book, wherever they relied on it, they actually did note that they relied on the Crown Court bench book, which have really good sample directions and all the write-up in relation to summations and DNA evidence. I don't know if there is a bench book for Turks and Caicos, or if there's one in the making. Of course, you know that your laws are not so available online. I think you have to pay what, $500 to get it, and then $200 for membership and all of that. So it may be that by our search we didn't see it but it exists. If it does, can I please have a copy? Well, can we please have a copy? Because I'm sure Mr. Queen's Counsel will be just as happy to get one. Partial profiles, I'm not going to get into what it is, because as I've said, Queen's Counsel mentioned it. I'm just looking again, I just pick a case. We've just taken a case and I've just looked at, in that particular case, what the court then said about partial profile, because very often it does arise. Yes, when you have a really good sample, all the loci are in place, whether 8, 9, 10, 15, or 14, and they're all in place, and you know, the Crown or the defense, whomever is relying on it, is really happy because nothing is missing. There are instances indeed where the DNA has degraded, and all of them are not present. The Crown still wants to rely on it for its circumstantial value. And the defense is probably saying, who knows if the ones that are missing won't exonerate my client? Judge, don't put them in. So here's the judge has this issue of admissibility on this point. So in Bates 2006, again, this is from the case, it says, we consider that the judge's approach to the question was entirely correct. We can see no reason why partial profile DNA evidence should not be admissible, provided that the jury are made aware of its inherent limitations and are given a sufficient explanation to enable them to evaluate it. So here the work for the judge. There may be cases where the match probability in relation to all the samples tested is so great that the judge would perhaps consider the probative value to be minimal and decide to exclude that, yes? So the prejudicial effect would be greater than the probative value. If the Crown is putting it in, we know that it can't go in under that test. However, the fact that there exists in the case of all partial profile evidence, the possibility that a missing allele might exculpate the accused altogether does not provide sufficient grounds for rejecting such evidence. So what is done then? He goes on to explain that. He says, in many cases, there is a possibility, well, at least in theory, that the evidence exists, which would assist the accused and perhaps even exculpate him altogether. But, here comes the but, that does not provide grounds for excluding relevant evidence that is available and otherwise admissible, though it does make it important ensure that the jury are given sufficient information to enable them to evaluate that evidence properly. Okay, so what about where the source of the DNA is unknown? Yes, because as I understand it now, when DNA is deposited from whichever of the different sources, there are some that you know what it is just by carrying out the test. There are other types that you really can't tell just by carrying out the test what deposited it. Yes, I don't remember what are the different ones now, but yes, I think, for example, saliva, you can't tell the source, and sweat, and probably skin. Don't quote me on it, but it's somewhere in the reading. Yes, but take, for example, semen. You can't tell that is the source. I think vaginal fluids also, because I think I was thinking to myself, wait, so why semen can't do vaginal fluids? You don't know. Anyhow, back to this. He said it was common ground that in cases where a reliable DNA profile has been obtained, as was the case here, but the type of cellular material from which it has been obtained is unknown, as was the case here, an expert can, in many cases, in addition to giving evidence of the profile match and match probability, give evidence enumerating the possibilities as to how the DNA has been transferred to the object from which the DNA profile has been obtained. And I will tell you, Reed and Garmson already 2 appeals heard at once. I think Reed are brothers, and they went in with knives that still have on the cellophane wrap and killed one gentleman named Mr. Ho, stab him up and kill him, and then they throw away the material. And from Garmson was this fellow who went around and his MO was to stick up people and rape the woman or have some sort of some form of sexual indecency. And of course, all 3 of them were saying they were not guilty. There was DNA. I think the reads there was another trial ordered for them. And if not ordered, certainly I'm sure their appeal was upheld. But for reasons that you'd have to read to truly appreciate that, and Garmson, his conviction, I believe, was upheld, if my memory serves me right. Okay, so let's go on now to look at the conviction solely on DNA evidence. Of course, many of you, I don't know if you had this experience, you'll have experience where the defense comes and says, oh, you have his DNA. Okay, we are going to that case. And so the issue is there really or often no only DNA in the case? And so what do we say here? So in many cases, there is some other evidence. It is insufficient of itself to prove guilt, but the DNA evidence corroborates that. And then you're going to see how weak, I put that in quotations, that other evidence needs to be, or can be rather, not needs to be, can be. So much so, you can see why the defense is saying, but it's only DNA you have. Yes, especially where, as we've said, the DNA can't tell you how it got there, no? So it can't tell you that the accused committed the offense. So we have to then look at the context of the offense in itself. Anyhow, so let's look at the examples listed here. You have the crown and gum, and I just lifted this, not from a case, from an article, which you'll see in the paper. It says where there were similarities in appearance between the accused and the alleged rapist. So that was the nature of the other evidence. So she could give a description. Of course, she can't say it's who, but she can give a description. Now you have Fitzherbert, where there was evidence of animosity and contact between the accused and the victim. So animosity, you're giving motive, contact mean that he had the ability to do so. It's not ability I'm looking for, that word with P, but be that as it may. The Crown and Butler, where the evidence was DNA, oh, it wasn't peace, opportunity, I think I wanted to say. And Weitra, where the accused lived nearby and stolen property was found near his home. And so I'm pointing this out to make the point that while technically it's probably, you're unlikely to find a case where there's DNA alone, what else that needs to be there is not usually of the sort of strength that counsel the defense would be alleging or would be arguing that needs to be there, yes? So I go on to the same point. It says, while cases where DNA alone, and this comes from definitely from an article, has also been used to convict, no, while cases where DNA alone has been used to convict are not easily found, there are cases where the barest of other evidence and a DNA link between the defendant and the crime scene to a very high probability has been used to convict. And one particular case was focused on that of the Crown and Roe. It says a police officer could at best give a general description of his assailant, but where the blood from which was recovered DNA linked to the accused was found on the officer's shirt. And the court then goes on, it says, as such, it was strictly not a DNA only case, although it came very close. So just a little blood, the officer could give a very general description, that means he could fit enough man, yes? But there was blood from this gentleman that clearly did not exclude the accused and to a high probability belonged to the accused, unless it's one of him brother, them or relative, no? Because you know, that profile generally covers all male relatives per se. The appellant sought to argue, this is Chief Justice Doyle, and he says the appellant sought to argue that because the DNA evidence was the only evidence of identification of the appellant, the conviction was somehow unsafe rather, and unsatisfactory. The evidence was a subject of expert opinion. It was subjected to close scrutiny by the trial judge, who directed the jury that they must be satisfied beyond reasonable doubt as to the reliability of the evidence and the accuracy of the DNA analysis. Well, the accuracy and reliability of the DNA analysis. It is probably founded on a safer basis for a conviction than the frailty, often attending the evidence of a single eyewitness who gives evidence of identification of an offender. There's no substance in this ground. So you see the court made very short thrift of the argument, despite, as you can see, the two strands, the DNA and the blood on the officer's shirt, which did not exclude the accused. So scientific evidence as circumstantial evidence. And I'm not, well, we know what that is, so I'm not going to go into it in any detail. I just notice here the case where it says, case of Chamberlain demonstrates is that scientific evidence must not always be overwhelming. And then we go back, of course, to the whole issue of partial profile and how far the ratio goes in excluding, well, in including the accused as someone who could have committed the crime. It doesn't always have to be overwhelming in order for it to be admissible or for the jury to place reliance on it. Rather, that it may be used in combination with other evidence to bolster the case. So yes, it can become exactly that, just a strand, pun intended, I suppose, of evidence that is being relied on, and that there are other bits. I remember a particular case, it might have been Chamberlain, in which the court found actually that the trial judge should not have allowed the DNA evidence on the prejudicial probative test, but found nonetheless that the other supporting evidence was strong enough for the conviction to be upheld. Now, voir dire on admissibility. And this came up in a number of cases, again, by virtue of your pretrial, your case management provisions. I believe perhaps you do address the issue of admissibility at a preliminary level, long before it gets into the trial. Yeah, perhaps it is done first at the beginning of the trial. I'd love to have feedback on that. The question of a voir dire can arise pre-trial as per Doheny and Adams, or as a preliminary issue at the start of the trial, which I believe occurred in Boyce, both Boyce and Carger. And just taking this from Michael Boyce, the issue of whether caution. This was a case in whether or not the accused had volunteered to give the blood, but there was also some new provision that had been introduced. And anyhow, the shorter argument was whether indeed he had been cautioned before the sample was taken. The Crown was saying, yes, we cautioned him through her officers. And he was saying, no, you did not caution me. And the trial judge, of course, the learned trial judge, held a voir dire. All the witnesses were called, evidence was led. His finding was that, yes, you were cautioned. And so I'm going to admit the evidence. So an interesting point arises from here. And I must confess, I didn't know it either. And neither did Queen's Counsel. So we found it interesting first when we just saw the ratio from the case, or rather the finding, and then had to go and read it in detail, which is, I must say, quite a pleasant read. It's pretty long. I think when you, oh no, this is probably 50 pages, but what a worthwhile 50 pages. Where the court, in holding that the issue of admissibility of DNA evidence was solely for the trial judge, and that the judge was right in not leaving the issue again to the jury in respect of the reliability. And it considered a number of cases. And I suppose when I go here, you will see the point I was making, because instantly I made a comparison, or Queen's Counsel and I made a comparison between this sort of evidence and evidence of some admission by the accused that he's now saying, boy, I never make it. And the issue of voluntariness, there being a whole void there, the judge, yes, accepting of the finding was voluntary, but all that evidence still going back before the jury for them to use it now to test reliability. But really what Michael Boyce is saying, and they're not alone, is that no, that's not necessary. It's just in the same way that admissibility is a question of law for the judge. The judge has decided, does not have to be left. Yes, because that was indeed the argument floated by the defense. And the court, in coming to his decision, notice. Ms. Defoe, it looks like I'm going to need some more water soon. Anyhow, let's finish this one. The court adopts the distinction made by the Court of Human Rights and by the US Supreme Court in concluding that the trial judge was correct in distinguishing between self-incriminating evidence of an accused, orally or in writing, and the ruling which he made in relation to the admissibility of the taking of the blood sample and the evidence relating to his analysis. The decision on admissibility was a matter of law, exclusively a matter for the trial judge. The finding of fact which he made in the course of his ruling were inextricably and exclusively related to the question of law. So the reliability of the forensic analysis depended on the evidence of the expert witnesses, and accordingly, he was correct in not permitting the jury to revisit the issue determined by him in connection with the admissibility of the evidence, namely whether the caution in question was administered. Rulings of law and such matters as to the admissibility of documentary or forensic evidence are exclusively a matter for the trial judge and not for the jury. A jury is only concerned with issues relating to with issues relevant to the guilt or innocence of an accused based on the evidence ruled by the admissibility by the trial judge. So you'll see the court went to this, making this separation between something that the accused say or write down, which they see as a part of him, and then the issue of the DNA, saying pretty much it stands on its own. It's something discrete. It doesn't require him to commit himself at all. Yeah, it's his own independent thing. And as I've said, come outside of himself in any event. But as I've said, it's a good read. Chain of custody. I won't linger here long either, because especially when I get to your case, I think it's Ridby, where we've covered this quite shortly. I think in this year, it's a 2022 judgment. I just mentioned the main points on chain of custody, that the whole purpose of that sort of evidence is really to demonstrate the integrity of the sample or the exhibit, yes? And it's a question of fact for the jury whether or not there's a reasonable doubt, there's reason to doubt the accuracy of DNA results because of the possibility that security or continuity was not maintained. And if there's a gap, and if the trial fact is not satisfied beyond a reasonable doubt that the substance taken from the accused and the substance analyzed, the evidence may still be admissible, but it's going to affect the weight. It says there must be, well, it goes on to say what type of evidence that must be there from the officers that established sufficiently. And importantly, also, proof of continuity is not a legal requirement and the gaps are not fatal. And as I've said, in 2022, indeed, I think it was Her Ladyship, Miss Laban Jackson, who tried this matter. I don't remember if the Court of Appeal, the judgment might have been written by Lord Justice Stolmeyer. I might be correct. I don't remember. There are so many of them. In any event, at the trial, defense made a no case submission. This was in relation to what was described as an absence of chain of custody in relation to a firearm recovered from the accused and had been submitted to the DNA lab in Florida. And on that basis, she made a no case sub. The judge said no and rejected the argument. Of course, the case went on. On appeal, that ground was renewed, as well as a new one was added to say that the scenes of crimes officer, who clearly would have given evidence that the gun that was put tossed out the window in the bush, he went and collected it and did all the necessary things and observed all the necessary rules in packaging it, sealing it, sending it to foreign, all of that. So the court rejected, on appeal, rejected both grounds. So the Court of Appeal held that there was no requirement for the scenes of crime officer to be an expert in the instant case. He was not giving evidence of any opinion as is required of an expert, which is really the same point that Crown Counsel had made at the trial itself. And they explained what exactly his role was and went on to note that as per Hodge and the Queen Damien Hodge, which we had looked at before and all those points on chain of custody, court held that we are satisfied the procedure followed in the instant case concerning the chain of custody was in accordance with the principle enunciated. And prejudicial and probative, I mean, we touched on that already. You see me listing here Pantoja and the Crown and going back to David Reed, Terence Reed, and Neil Garmson. And I pause here again from directions from the reliable Miss Defoe as to how we proceed. This is not so long, it will take up less time, but it is still an area which I'm just about to begin. So Miss Fu, is our audience still enraptured and want us to go on, or do they want to pause for 5 or even abandon the rest by virtue of how late it already is?
Thank you, Ms. Kula. I'll throw it back to our attendees. Perhaps you can indicate in the chat what your preference is.
I'll get some water in the meanwhile.
Yes, sure.
It's like our audience also stepped away for some water too.
Oh dear.
Yes, I do have one response.
What
Says he's
did
happy
that?
to. Our Chief Magistrate asked us to carry on, please.
Okay. Yes, Madam Judge, I shall soon be finished. How long have I been going on? Actually, not that long, all things considered. How long have I been at it, Miss Defoe?
I would think just about an hour.
About an hour, okay.
Yes.
Here I was thinking that Mr. Taylor was going at it long. I am no better than he is. Birds of a feather, they say. Here, clearly
So I have
truth.
4 votes for you to continue, Ms. Kula.
Okay, very well. As I've said, this is the shorter part of it, and we'll be done. Yes, so where are we? Just to recap. No? So as I've said, we did our intro, we looked at the law, we're considering the tripartite considerations, and we divided them following a trial. Yeah, so we did pre-trial, we did during trial, and now we are at post-trial. So we're kind of shifting, in a sense, from the trial level where the matter would have been tried, to the appellate level, where the matter is now being scrutinized. Yes, and that, as I've said, will go fast enough. Okay, considerations post-conviction. And of course, we know the different grounds on which an appeal can be brought, and specifically, or bases on which the appeal can be brought, and then the different grounds in particular in which the DNA issues can fall. And as we read the cases, they are rich with how defense counsel formulate those grounds and every aspect of the DNA evidence itself that is complained. And of course, some appear more frequently than others. So we're going to look at that shortly. And we're also going to look at this extra aspect of so two things, yes? Bringing the appeal generally about what happened at the trial and the evidence that was led there. And we're also going to now look at evidence that was led there, that is fresh evidence applications, that permission is now being made, application is being made to bring that evidence at the appellate level. And of course, Queen's Counsel and I have rehearsed your law more for us than you, because clearly you know these things already, but for us, they are still somewhat new. So as I said, bear with us where we have slides that clearly speak to what is common knowledge, but for us would fall within the presentation. No, so the Court of Appeal ordinance that gives the power for the appeals to be brought, and the bases on which they are to be brought is stated here. So we're looking at rulings at trial and such matters as the admissibility of the forensic evidence, whether on questions of law alone or questions of mixed law and fact. And you notice I have here whether the Crown has a right of appeal on these issues. I didn't have the time to research that, but more and more in the Caribbean, you see that the Crown is given a right. Mind you, in some territories it was done a long time ago. Others like Jamaica have just caught up with Queen's Counsel. I think it just last year the Crown got power in a limited sense, or more widely so, Mr. Taylor, to appeal. No? So I'm not sure about Turks and Caicos. So I did not essay a view. Next, I get it wrong. So okay. So where a jury has reached its verdict in part, and more so too though, going back to the question of appeal, if it means the Crown's case gets thrown out at the no case submission stage, because the judge made an error in law in not accepting DNA evidence on which the most of his case was based, whether they could bring that on appeal. Okay, where a jury has reached its verdict in part on the basis of prosecution DNA evidence, and appellate court will review the evidence to ascertain whether it lacks probative force to the extent that a reasonable jury would not have convicted on that evidence. And of course, it may be, as we said earlier, that the verdict may be overturned unless, of course, there's sufficient other evidence. And I've looked here, oh dear, it is even too fine from here for me to see it. The Crown and Waters, a case from the UK, it turned on poor, well, what I put in bracket as poor, inconclusive DNA evidence that had been placed before the court and on which the accused had been convicted. So shortly, the accused charged, convicted of several counts of burglary. The Crown's case was based mainly on DNA evidence that was extracted from cigarette butts found at the crime scene. The other supporting evidence is what we call poultry, and it was really limited to 3 bases. What was the first one? That the DNA showed that he was a male, okay. That the accused is a male, The accused lived in the surroundings, and the accused was allegedly a smoker. I mean, we can see how poultry looks from a distance, no? However, he had brothers who it had not been shown by the Crown that they did not fall within these descriptors. And in fact, I think one of the 2 brothers had been charged, another one was still there and nothing was said about him. So remember we said earlier that the DNA, generally, all the male relatives of the accused are really included in that. So in terms of the loci that are used to determine who deposited the DNA, no? Is the accused is included or excluded? And so the Crown, this is where the other evidence comes in, that where the DNA stands over here, so, and you have a situation where the accused has other male relatives that could probably be implicated, that the Crown is going to have a duty to show how those are excluded. But in Waters, certainly at the trial stage, that had not been done. And the Court of Appeal, of course, picked up on it and said the court, upon appeal now, the Crown, by sleight of hand, was trying to see how they could repair that. But of course, the Court of Appeal was having none of it. So it says, on appeal, the court was urged to look at 2 arguments in the alternative. The first argument is whether based on new DNA evidence, the conviction could now be considered to be safe. This new DNA evidence was offered at the trial, you know, but the Crown is saying now that we have it and the court knows that we have it. Isn't the conviction safe? And two, in the alternative, that if based on the said new evidence, a retrial should be ordered. So they start at the top. Can you please use the proviso and uphold the conviction? And if not, then give us a second bite at the cherry. The court said, absolutely not. And they say on the first argument that you make about the new DNA evidence, you say on the former it was held that extraneous evidence should never be a consideration at this stage. And they held that the trial judge really should have upheld in no case. It really was not one of those that he should have allowed to go to the jury. And the court, however, though, hastened to add that their findings were confined to the narrow facts of this particular case for them. It was not an indictment at all on DNA evidence, or even DNA evidence where we see beer or weak, as we saw earlier with the policeman, that to support the conviction. This was this particular case that they were making comments on. In the second argument, the second point, in the alternative, the retrial, the second bite at the cherry, they say upon the issue of whether a retrial should be ordered, considering there was more convincing DNA evidence at the stage of appeal and more evidence and more could even be gathered. So the Crown is saying, not only do we have this now, because I think they carried out a different test using some different equipment, and that was more accurate. That lessened the probability of who could have committed it. Not only that it didn't exclude, but it made it less as to the persons. So the court made 2 points, and rightly so. It says, first, it would be wrong to have someone have a charge hanging over their heads on the basis of what may be found was wrong, and that the gathering of all relevant evidence should have been done earlier. And the defense, to their credit, made this very good point. The defense pointed out that if the judge had properly directed himself, he would have acquitted the accused from the first trial. And so this argument of a retrial would never have arisen. I must say, I really feel very satisfied, even with a prosecutorial background with this decision by the judge, because I really believe Crown Counsel was perhaps wearing one hat at the time of this appeal. Okay, failure of the prosecution to provide material for the defense so that it could be tested. And that comes out of a case of the Crown and Button, again from Queensland. So much so, I think it was the chief who delivered the judgment, and he called it, you know, the usual. It was a black day in the history of the criminal justice system in Button. I think it was a gentleman who had been charged and found guilty of having sex with a 13-year-old child. And they tested her, the swab that they took from her, I think her clothing, but the sheet on the bed also had a stain. And while that had been taken to the lab, that it had not been tested. And the reason that was given for it was that, well, it was unlikely that we're going to find evidence on it that would seek to, would help the Crown to show that the accused was actually the one who committed it. Yes. And so those samples had not been analyzed, even though it was later found out they excluded the suspect, I believe. And, you know, Justice of Appeal Williams, it was very forthright in the judgment and made it clear that the Crown needs to remember, the Crown and of course the officers with whom they work, that there is a twofold purpose of DNA testing. It's not simply to identify the perpetrator of a crime, yes, but to exclude a possible offender as the perpetrator, yes, or a possible person as a perpetrator. So let that be a lesson to prosecutors, and as I've said, their investigative arm to ensure that, as I've said, you remember that, well, we are two hats, and both of those must be respected, especially one could arguably say even more so your role as a Minister of Justice above that. And of course, as we've said, the court as a keeper, the judge as a keeper of the gates, that these questions are scrutinized, or these issues are scrutinized, and opportunities are given to defense who are well prepared to address them. Okay, so the last point, woohoo, we're down to fresh evidence. Yeah, so I hope we're all feeling fresh at this point because of that. Okay, that's a corny one, but it was worth the injection. Okay, so fresh evidence, we go to Rule 18 of the Court of Appeal rules. And of course, as I've said, you already know what that is for, with power, so we'll just go over that. And the language, though, I must say, it seemed a little different from the language that I've looked at in the other territories, Jamaica, and the other ones that the law school serve. But when we then looked, because having looked at the statute itself, I wondered about the interpretation, how wide that is, not having the deemed necessary and expedient in the interest of justice. When Queen's Counsel, Mr. Taylor, read it as we're preparing. So we said, well, let's see how they interpreted it. So because of that, we went back and started digging up a case from your jurisdiction, Joseph and Regina, 2019. And the definition really is the same. And I think has the same ambit and would make for the same admission of evidence. That is what that one is accustomed to. So it says that before fresh evidence is permitted to be called, it must be shown that such evidence was not in a true sense available at the trial. And if it was, and there's a reasonable explanation that exists for not adducing it at trial, yes? And of course, there must be sufficient relevance to make the evidence or the request, the application meaningful, and the evidence, of course, must appear to be credible. So it's the same if it is deemed expedient, necessary, and expedient in the interest of justice as that overall umbrella that appears to cover that test. And the last case in which Queen's Counsel, Mr. Taylor, actually did appear is Christopher Murray. And this is just looking at the stance of the court when an application for fresh evidence is made at this stage. And Chief Justice Panton, as he then was, heard the appeal. The accused man had been convicted of buggery. And a young fellow, right, Queen's Counsel? And I've actually put what the court said because I like this, the language again. It said it should be noted that at the trial, the applicant had called the government analyst, Miss Brightson, very professional, no? To give evidence on his behalf. So it was he who actually called the analyst in this case, the defense. She said that she had received anal and buccal swabs from the complainant and the applicant, and she did the DNA analysis on them. Unfortunately, the results were such that she could neither include nor exclude the applicant as to whether there had been any sexual contact between the parties. And it is in respect of this area of the evidence that the applicant is seeking to place new evidence before the court. And of course, his lordship then looked at the state of the law, which he broke down into 4 points. I think we've addressed it under Joseph a while ago. So I won't necessarily go back there. And he noted an observation made by the Deputy Director of Public Prosecution, Mr. Jeremy Taylor, that an affidavit was necessary from counsel in respect of the unavailability of the evidence at the time of the trial. And the court said this point is of importance, and there ought to have been such an affidavit. However, there are documents before the court that indicate that there may have been a failure on the part of the government analyst to disclose certain information as to the possibility of a further test, which would have alerted counsel. And I think that's very important that the court, despite what Ms. Queen's Counsel is saying, no, well, Mr. Taylor, as he then was, and despite the fact that it was the defense who had called Ms. Bryson and the test was inconclusive, that the court says, but look, the Crown, and it goes further to the Crown's responsibility, that the government analyst, there was certain other information that should have been disclosed. And I should just pause to say that had to do with a YSTR test. That's a YSTR test is more pointed. It's done on, on the DNA, clearly. And it's more pointed. And I think at that stage, at the government lab in Jamaica, the test was not carried out at the government lab, but there was this other private institution which operates out of the University of the West Indies, that Mona, that actually did carry out those tests. So even though Ms. Brightson did everything that she could within the resources that she had, she was not, this saw how far the test took it. But when they gave it now to Professor, let me get to his name on the other slide, Professor McLaughlin, he was able to do that test. And the test purported to exclude the applicant from involvement in the events complained of by the child. So it's so important about getting the full information, disclosure, the knowledge, everything just, in my view, just kind of comes together as to many of the points that we've looked at so far. And it says this report purports to go further than Ms. Brightson's report does. And this is an indication that Professor McLaughlin performed a test that was not done by Ms. Brightson, and so he was able to achieve a definitive result, whereas hers had been inconclusive. And it says, of course, because the court is always wary about whether or not persons, parties, whether the Crown or the defense, are simply cheeking to get a second bite of the cherry. It says the court is wary as far as the reception of new evidence after trial is concerned. However, in circumstances of this nature, careful examination of the situation is required, as the court must always seek to avoid an injustice being done to an innocent individual. And in the circumstances, we grant the application and propose to hear the evidence of Professor McLaughlin. No? So there we're ending on a successful note all around, if you ask me, in the interest of justice, which is what all the roles come together to serve. And we don't have an end slide. Mr. Queen's Counsel had pointed that out, but we decided, we just asked you orally to clap because we're done. And so, yes, that is it. Chief Justice, ladies and gentlemen.
Thank you
Counsel,
so
do
much.
want to add anything?
No, well, I would just add that in relation to Christopher Murray, the Court of Appeal, it seemed that they were considering whether or not to order a retrial. I had contacted the complainant's parents. They weren't interested in going through with a retrial, and they had migrated from Jamaica already. So the Court of Appeal, their oral judgment, quashed the conviction, entered a verdict of not guilty, and did not order a retrial in the matter. But they gave an oral judgment, they gave a written judgment.
Properly so. Properly so. Okay. I believe that is it then.
Queen's Counsel, Mr. Taylor, Ms. Kohler, thank you for this very robust and thorough presentation. Ms. Kohler, I heard your concern on the availability of our legislation. So I would just like to point out to you that our revised laws will be found at no cost on our Attorney General's website.
Yay!
Yes. And a link to this website is on TCI Lee, and I will email this link to you and to Queen's Counsel, Mr. Taylor.
Thank you very much, Mr. DeFore. You know that I painstakingly look on the screen and peck the provisions of the police force.
Yes. And typing them out because we can't print them. It was a real search. It was like, yes, Easter eggs hunting all over again.
Yeah, so we will help you with this. So we'll now hear from Her Honor, Ulrika Salva Gardner, Resident Magistrate, who will deliver a vote of thanks to you on behalf of our JEI and our attendees.
Good afternoon, can you hear me?
Yes, I hear you now, Ms. Salva Gardner.
Okay, I'm just trying to ensure that you can see me, but I think like Ms. Kohler, I'm not really as technologically savvy as it comes to using Zoom meetings. So I hope if you can't see me that you can hear me.
I can hear you very well, Your Honor.
Okay.
I can hear you very well.
Right, let's see here.
And now we see you.
Okay, there I am. Good afternoon, everyone. Mr. Taylor, Queen's Counsel, our guest presenter, commenced his presentation by reminding us of the fact that the use of DNA evidence in court is just over 30 years old. For those of us who commenced our field of work after the 1980s, we can hardly imagine a time when the use of DNA evidence was not available to us. In family court, we regularly make use of such requests as DNA reports where there are issues of paternity. In criminal matters, it tends to prove or disprove a suspect's involvement in an alleged offense. Prosecutors and members of law enforcement agencies rely on it in order to secure or support the charges laid against the defendant. Defense counsel are tasked with the job of ensuring that the evidence is clear, scientifically valid, uncontaminated, and that the expert's evidence is admissible and sufficiently reliable. Quoting Mr. Taylor once more, DNA evidence does not just walk in the door. There has to be a sufficient nexus or foundation for its admissibility. Our second guest presenter, Ms. Kohler, outlined the basis for which we can consider, accept, and/or challenge the DNA evidence presented in court. The existence and use of DNA evidence is one that continues to evolve, and each one of us bear the responsibility for ensuring that we continuously evolve as the science does. Today, DNA evidence is used to assist the triers of fact to look into an unbiased window to the truth, a most useful tool to have at our disposal. Good afternoon, everyone. As Ms. DeFore so ably introduced, my name is Ulrika Selfer-Gardner, resident magistrate here in the Turks and Caicos Islands. I've been tasked with the honor of offering the vote of thanks on behalf of the Honorable Chief Justice, Mrs. Mabel Agerman, who sits as the chairperson of the TCI JEI committee. And also on behalf of the TCI Judiciary, that is the Honorable Justices and Magistrates of the Court of Appeal, Supreme Court, and Magistrates Court. We wish to first and foremost thank our honored guest presenters, Mr. Jeremy Taylor, Queen's Counsel, and Ms. Meridian Kohler. Your presentations were not only valued for its content, but also for the fact that you have chosen to take time out of your busy schedules to share with us your wealth of knowledge and insight in the field of DNA evidence, its collection and introduction in court, and the considerations that must be had when it is being presented by the prosecutors and when being challenged by the defense. Last but not least, to you, our attendees in law enforcement, defense counsel, and members of the bar, we wish to extend our sincere thanks to you for your attendance, your participation, and continued support for the Judicial Education Institute and its programs such as this. Your presence is evidence of the importance that you have placed on the pursuit of the overriding objective and the interest of justice in these islands. Finally, to the Secretary of the JEI, Ms. Aisha DeFore, we rely on you and your calm capabilities in seeing that this event and others like it are effected smoothly. So we offer our sincere thanks for all the hard work you've put into this. We started on time, we came, we saw, and we conquered the subject of DNA evidence and its judicial considerations. We trust you found this presentation as informative and thought-provoking as we hope it to have been. We thank our presenters once again. It is indeed a privilege to have taken part in a presentation with such experienced members of the legal fraternity. Thank each and every one of you for coming and hearing our presentation, on judicial consideration of DNA evidence. A pleasant good afternoon to you all. Thank you.
Thank you, Your Honor. Good afternoon. Good afternoon, everyone. Thank you so much.
Queen's Counsel, would you like to say thanks on our behalf?
Yes, well, thank you again for the invitation. We certainly enjoyed it. We started out by not getting to know your, sort of without any knowledge of your jurisdiction. We think we are a little bit more informed, at least on what is on the law books. We don't know what happens in practice, but we put the best face on it. But thanks again. We look forward, if we can do, to participate in other ventures that you might have. And if I may make just a personal plea on behalf of myself and Ms. Kohler, can someone convey our greetings to Ms. Loban Jackson, Justice Loban Jackson, for us? She was our senior at the Office of the Director of Public Prosecutions. We didn't see her here, but we want to know that, we still remember her.
I will do that, Mr. Taylor. It would be my pleasure. And she did express disappointment at not being able to attend today. And it's because of her message that prompted me to request whether this could be recorded for her benefit and for the others as well who might have missed out and might want to be able to review it in the future. So thank you so much.
As we say again, thanks again. We thoroughly enjoyed it.
Thank you. I second Queen's Counsel. And have a great one, Turks and Caicos. I take it you're eating or going for lunch, just like ourselves now.
We are, yes, thank you.
Okay then, bye-bye.
Yes, so now that we've concluded, our attendees, you are excused. Thank you so much for joining us.